Hello, beautiful humans. Good afternoon, good evening, or good night, depending on where you're at. I am Bob Mata. This is Defense Diaries. This is Felonious Friday. I think 5 weeks in a row, which is pretty good. And once again, as always, I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
Hey, honey. So we got another Felonious Friday, and it's a pretty good one, I think.
Yeah, it's packed with major developments, breaking developments that literally happened within the last 48 hours.
True that. True that. We are covering 4 significant cases today, and I want to tell you the developments in at least 2 of the cases are going to blow your mind. We've got last-minute stays of execution, which means they're trying to kill somebody, and the governor stepped in and said, "Hey, don't do that," or the court stepped in and said, "Hey, don't do that." So those are the couple of ways that can happen. So it was the court in this. Wait, you're giving spoilers, girl.
Oh.
But we also have allegations of law enforcement fabricating evidence. Wow. Can't believe that.
Yeah, right.
And ongoing battles over constitutional rights that go to the very heart of what we do as defense attorneys and what we are yammering on about on this channel all the time.
Yep. Today's lineup includes the Roberson death penalty case out of Texas, where just yesterday, the Court of Criminal Appeals granted a stay of execution scheduled for, like Bob said, like next week. We've got Kelsey Fitzsimmons, the the Commonwealth filed their response to her appeal on the bail issue. That's where, as you guys know, the wounded Kelsey Fitzsimmons is still fighting over her bail revocation. And then we've got the Kyren Lacy case.
Kyren.
Oh, yes. Kyren. And this is our first deep dive into this tragic story involving the late LSU football star, where stunning new evidence suggests law enforcement may have fabricated key facts to support charges. Wow, it happens in more places than Massachusetts.
Can you believe it?
I'm shocked.
Can you believe it? The Commonwealth of Massachusetts is not the only state where corruption happens. Go figure.
Go figure. Again, Bob and I not shocked. We know this, and the public is, you're all learning it too.
Yeah.
So, and then we're going to cover some of the ongoing stuff between Karen Reed and Aidan Carney, specifically their motion to examine Karen's phones for evidence of the conspiracy, which it sounds like they are technically still investigating Kyren as well. So,
I mean, we know from Bettero's latest affidavit that there's a 2025 investigation going on regarding Aidan and Kyren. So what we're not going to be getting into is the stupid shit. None of the rumor mill, none of that crap. That's for the other folks. We try to stick to the law here. But before we dive in, do me a huge favor. Do Allie. More important, do Allie a huge favor. And remember to hit that subscribe button, ring the notification bell, share, subscribe. And if you really love us, think about becoming a member, because we'll monitor throughout the show. Allie likes to keep track of who's doing what. And then also one other announcement, we've got a wheel spin going today. Another free t-shirt from our Bonfire merch store. You get to pick whatever shirt you want. Get some nice long sleevers for fall coming up. So we got a lot of great slogans, sayings, DD stuff, all the DD merch you could want, even though Mandy has been making some amazing stuff that we should be putting on the shirts, like the thing that we have on the screen all the time. I heart due process. Mandy creation. It should be on a shirt. It will be soon, but not yet. So, all right. Let's start with Robert Roberson, which is, as Allie stated, a death penalty case. Let's get us rocking and rolling on that, babe.
I mean, this case represents everything that's wrong and occasionally right here, but everything that's wrong about our death penalty system. Robert Roberson, he's 58 years old. He has been on Texas death row for over 22 years following his 2003 conviction for capital murder in the death of his 2-year-old daughter, Nikki Curtis. Well, and the central issues here, revolve around what we now know and what Texas has recognized as highly questionable science, the so-called shaken baby syndrome diagnosis.
Which was a thing for a long time. Like, that thing became a thing. And it always scared me just because of kind of seemed like a lack of actual science behind it. I think anytime a baby ends up dying suddenly, I think we want to blame somebody just because it's so shocking and so sad. And I think that was probably the impetus into, all right, is there something else going on here? Like, what's happening? There were no signs that the baby was ill. As you'll see in short order, that was not
the case here
in this particular case at all. And just for the record, baby, it's Robertson, like my first name with a son of
but there's
Robert.
no T in there.
But there is. I promise there is. All right, so I'm going to give you a little bit of a timeline of the events so that you have a better idea of what we're talking about. Of course, having background on the case helps when we're talking about a case that maybe you've never heard of. So go all the way back to December 17th of 2002. Nikki Curtis, and that is Robertson's 2-year-old daughter, had been severely ill. Okay. Medical records show that she had been taken to a hospital more than 40 times in her short life. 2 days before her death, she had registered a 104.5-degree fever at the doctor's office. She was sent home with a drug called Phenergan or Phenergan. Have you heard of that, babe? Do you remember a medicine like that? I don't know that we ever used it with our kids. It didn't ring a bell when I was researching it.
No, I mean
it's Phenergan. Phenergan.
No, but it sounds like it's in the phentermine family.
Yeah, I mean, maybe. Oh no, it's pH, honey. It's pH. Right?
Oh,
I don't know. Okay, but this part's critical. So that particular medication at the time did not have what it has now, which is a black box warning saying that this medication is deemed to be dangerous for children. So it's got that FDA black box warning now.
Wow. So she's already critically ill before the events that lead to his arrest. And
Yeah.
does anyone even know about this trial wise? Well, I guess you'll get to it.
I mean, it's like when you're kind of reading through what dropped recently in terms of, I don't know. It's one of those cases where, when defense attorneys don't do a good job, they're a part of the problem, right? They're not a part of the solution. And I'm not certain that's what happened here, but the more facts I read about this, I'm like, holy shit, there was a lot here. It seems like that they could have put on an evidence that may have stopped this from, becoming an execution.
Right. So give us the rest of the background.
All right. So on the morning, her father discovered on the morning of December 17th, her father discovered her unconscious with blue lips, and he then rushed her to the emergency room. But here's the thing, which I, again, don't know if this was litigated at the time. I happen to think that it wasn't because he was undiagnosed. Robert Robertson was autistic. And that ultimately, in terms of the state's case, became a weapon against him.
Wow.
Robert showed little emotion at the hospital. He didn't react the way that nurses and doctors would expect a distraught parent to react.
Wow. So law enforcement, of course, interpreted his flat affect as consciousness of guilt rather than a neurological condition.
Yeah, how much do we talk about that on our channel? That like you can't judge jack shit on
No.
on how somebody's responding to trauma. You
Right. And
can't
we
do it.
all know, most of you all know out there now, once a cop forms that initial opinion, like, oh, all right, well, something's not right here. I'm looking into him, getting him to focus on something else or to think about that it could be another reason. Forget about it.
Nailed it. Because within 3 days, Detective Brian Wharton arrested Robertson on a capital murder charge. Case goes to trial in 2003, and ultimately, Robert Robertson was convicted based primarily on the shaken baby syndrome diagnosis. Prosecutors argued that he had violently shaken Nikki, causing her brain injury and subsequent death.
Wow. So Texas recognizes that the medical understanding of shaken baby syndrome has evolved significantly since then. Texas has a junk science law that
Woo! I
became
love that.
I know, I know. I looked at a couple of them and I can't remember now what states it was. Maybe it happened to be Texas because I was thinking about it, well, if they had this in Indiana, maybe Richard Allen wouldn't be in prison right now. But their junk science law in 2013, they passed legislation allowing people to challenge their convictions when new scientific evidence emerges that undermines the basis of their conviction.
God damn it, that makes so much sense. That makes so much sense. I can't believe it. I mean, I'm jesting, but come
Right.
on. Like
Yes. So,
every state in the union should have that on books.
right. So some states have it like this, where you can, all right, this is junk science, old junk science. Now you get to like literally challenge your conviction on something where you you may have been all out of opportunities to do so. Meanwhile, in Indiana, they are still on today's date admitting junk science, despite the fact that so much of the scientific community recognizes it as junk science to imprison people today.
Yeah.
So, but
Oh, which
I digress.
speaking of
I digress.
which, I have to digress as well. I forgot to give the date. That's become something that Allie was adamant about. She said, "Hey, bonehead, why don't you give the date when we're doing these?"
I mean,
And it was a great idea. Today is October 10th, 2025. So there you go. All right. So look, basically, what's been going on recently is that expert after expert after expert has now come forward stating that Nikki's death was not caused by shaking. The evidence shows that she had undiagnosed chronic pneumonia. That would maybe explain the 40 trips in 2 years to the doctor. I mean, that's a lot. That's a
Yeah.
lot of trips to the doctor. So again, remember she was prescribed that Phenergan,
Fenergan.
Fenergan, Fenergan,
Fenergan.
Fenergan, Fenergan. Like, and please, in the comments, this isn't a person's name. Fuck Big Pharma. Please don't correct me on if I'm butchering the pronouncing of
They
some
can
kind of.
correct us. We like when
No,
people
I
tell
love
us
it
the
when
right
it's on
thing.
names or
It's
towns.
fine. They
When
can
it's
do it
Big
for
Pharma,
anything.
save it. Save it. I disagree with Allie. Save it. Big Pharma, go fuck themselves.
All right.
So which suppressed her breathing even more and led to brain swelling. See what I was saying about the whole Big Pharma thing? See how that came into play right there? Her condition ends up devolving into sepsis, causing a bleeding disorder that made her bruise easily.
So, did any of this get into trial? Like the fact that she was sick or on medication, like any aspect of this identified or even considered at the trial level?
That's a great question. And the answer is not at all.
Oh,
No, the jury in Robertson's trial never heard the extent of how sick Nikki had been. Can you, like, when I read this, like my brain exploded, fell onto the ground. I had to pick it up, put it back in my skull, try to fit the dude. No, the jury never heard the extent of how sick she had been. They never heard that she had been to the hospital more than 40 times. They never heard about the dangerous medication. And they certainly never heard that Robert had autism and that he was on the spectrum. So, because he wasn't diagnosed until 2018, years, 16 years, as a matter of fact, or 7 or 15 after his conviction.
All right. So let's talk about like what just happened procedurally wise.
Okay. All right. Tell me, baby, what happened?
I thought you were going to tell me.
No, man, we know
Uh,
you're the law girl. I'm just the guy who
oh,
stands here
stop.
and learns good shit from you all the time.
So, well, going backwards procedural history wise, on October 17th, 2024, he was initially scheduled to be executed, but in an unprecedented move, a bipartisan group of Texas lawmakers subpoenaed him to testify at the state capitol in Austin, which triggered a separation of battles, power, and the Supreme Court issued a stay less than 2 hours before the execution was set to take place the first time.
Oh my God. I mean, imagine being somebody on death row. Okay, you're literally minutes away from being executed, and you're waiting for, just like in the movies, you're waiting for the phone to ring where somebody out there in the world makes a call to save your life. It's unbelievable. And the thing that's interesting here, babe, is that you had staunch pro death penalty conservative lawmakers actively working to stop his execution. That's unusual, but I also think it makes sense. If you're pro death penalty, the last thing that you want to be doing is killing innocent people.
Yeah, it looks really bad for the death penalty.
Yeah, it's not real good for your argument.
No. I mean, your point is well taken. It's the worst thing that can happen for a pro death penalty people, legislatures, whatever, is to execute an innocent man.
It's a bad look. It's a bad look.
So the courts eventually they ruled that like a legislative subpoena can't indefinitely block execution. So July of this year, the attorney general, and this is unusual that he got directly involved, but I don't know, maybe he realized this guy is like stuck in an indefinite loophole.
Yeah.
So he requested an
The
execution
Matrix.
date. Right. In July, he requested it and he asked and got a new date for October 16th, 2025.
Oh my God. And then yesterday happened.
Right. Just 7 days before his trial, the Texas Court of Appeals granted his stay of execution and remanded his case back to the Anderson County District Court.
And what was the basis for this most recent stay, honey?
The court cited their own 2024 decision in Ex parte Rourke. It's another shaken baby case. So in that case, they granted Rourke a new trial, finding that the scientific evidence had evolved and that it was more likely than not that he would not have been convicted based on current scientific understanding.
Yeah, and interestingly, in a concurring opinion, the Court of Criminal Appeals Judge Burt Richardson wrote, and I'm quoting here, that, quote, there is a delicate balance and tension in our criminal justice system between the finality of judgment and its accuracy. Here, Judge, based on our ever advancing scientific understanding. God, I love when I read an opinion from a judge, concurring, majority, whatever the case may be, or even dissenting, that seems to fucking get it. It gives me, it really, it heartens me to know that there's people on the bench that seem to fucking get it. So thus, when moving forward in such a way, we should require the highest standards of accuracy so that we can act with a reliable degree of certainty. That is not possible with the record we presently have before us.
Yeah.
Everybody, round of applause for Judge Burt Richardson. Let's go.
I mean, it's shocking that how, you know, the Texas judiciary can be so candor about the risks of executing someone based on outdated science, while Indiana still convicts and sets someone up for execution based. Oh well, no, he wasn't eligible for the death penalty.
No death penalty. Just 130 years, babe.
I mean, right, send someone to die in prison on science they already know is outdated, and then prevents you from even telling the jury how bad that science is.
And don't forget coerced confessions.
I know,
Don't
but
forget
I'm
those.
just keeping it within the bounds of what we're talking
I
about here.
understand.
It's
I
just
just like to
it's
remind the kids, about
yeah,
that
they
case.
know. They know.
So what happens next, babe?
The case goes back to the trial court in Anderson County to determine whether Robertson's case warrants relief under that holding in Rourke. And his attorney stated that there's no court in which the state could appeal this decision, and no one can rush to set another execution date. The case must go through the trial court process first, obviously.
God damn it. Hold on. I'm trying to find this. Why can't I find this? I had a perfect. Oh, here. This is the soundbite after your little laugh I wanted to play.
You have a kind of sick desperation in your laugh?
When did I laugh?
Like when I said, "What happens next, babe?" And you went,
Oh yeah, there was a sick desperate.
there was kind of a sick desperate a little bit. All right. So,
Sick desperation in your laugh?
oh wait,
Sorry, it's on a
sorry, it's on a loop. It's on a
My
loop.
God,
Don't yell at me,
tech
babe. Don't yell at me.
wizardry. So notably here, a grand jury had already reviewed some of the evidence and declined to indict Robert on witness intimidation charges related to his advocacy. Is that what's that about?
I mean, it's a separate matter, but yes, what we're seeing here is a confluence of factors involving science, autism advocacy groups, highlighting how the criminal justice system fails neurodivergent defendants, bipartisan political support, and a court finally willing to acknowledge that the scientific foundation of this conviction sucks and has crumbled.
All right, all right. So do we know that? I thought you said something about the lead detective changing his mind
Yeah,
too.
yeah, which obviously is huge, especially when you consider that most cops never change their mind, even when people are fully exonerated. They're like, nah, hey, he's the guy. I got the right guy. He's the right guy. So, yeah, but here, former detective Brian Wharton, that probably helps that he's a former detective in the twilight of his life, maybe, or he's in the golden years. Probably sitting around thinking about this case a lot. And it's a case, anytime you have a death penalty case, this thing's not going away until an execution takes place. It just keeps popping up. There's obviously many, many attempts to save the person's life. So it's not something like he could have just sat around and forgotten about it. It's probably gets emails every other day. He's like, God damn it. God damn it, another email about it. So ultimately, he states publicly that they got it wrong. He arrested Robertson without the knowledge of Nikki's extensive medical history and was unaware, of course, which I can't blame the cop on because Robertson didn't know. I mean, probably knew that he viewed things a little differently than other folks, but
Right.
he wasn't diagnosed, right? But ultimately, the cop didn't know he was autistic either. So he's now, not only is he decided to change his mind on whether or not he had the right guy, he's now advocating for Robert's release.
I mean, that goes to show that he must have always had like some underlying, like he started putting
Reasonable
dots
doubt.
together as soon as as soon as this came together, and probably also knew in his heart of hearts how much Roberson's, and I'm not going to stick a T in there. The name spelled Roberson. So, I don't get it. But anyway, on his affect, like that he was not showing the emotion they thought he should show it. I think it suggests to me anyway, like that this guy put a lot of weight in that in coming up with his own suspicions and driving his case there for him. But I mean,
you're right. I Googled it. No T. Roberson. Oopsies.
So anyway, from a defense perspective, I mean, this case is basically the perfect storm for how the system can fail. It's perfect for those anti-death penalty people to show how fucked up it is. You
Yeah.
got your outdated forensic science being presented as a settled fact, a defendant with an undiagnosed disability that affects how he presents emotionally and how they interpret him, a rushed investigation that failed to consider alternative explanations, and a finality focused appeals process that made it nearly impossible to introduce new evidence. So even when that evidence fundamentally undermines the conviction. So it's like one of those cases that you can be like, you've got all of it. It happens. It happens all the time.
Yeah, it's a see, I told you so case. That's what it is. But wait, I had one hair and then I compared it to the other hair in very good lighting and they looked the same. He's guilty. I mean, like they used to do hair comparisons. Like we're like, oh, the two hairs look similar. Guilty. Like, I mean, it's all the same shit as obviously the statute in Texas recognizes, and good old Judge Burt. The scientific advances are unbelievable in terms of what we're able to find out that we had no ability to be able to do that prior to. And you have to acknowledge the fact that it exists. We can't pretend like DNA is not a big deal. We can't pretend like now we can take even just the most microscopic amount of DNA and still be able to develop a profile on it. Like we can't pretend that shit doesn't exist in the world. And there's just, it's going to continue to get more and more advanced the longer this thing goes on. What I'm really hoping that they develop is that somebody out there is furiously developing a way to detect whether or not something has been made by AI and is complete and utter bullshit, because it is terrifying. I've been making these like deep fakes on Grok and it's horrifying. Like people are like, what? Like I did one the other day for our granddaughter. They had sent an adorable little picture of our granddaughter on her porta potty or whatever, the little poopy chair thing. And, you know, they're trying to potty train her. And then I, of course, turned it into something funny and, you know, which made the picture come alive. And like, Allie's like, what? What? Is this isn't Lila?
So no, really, the pictures were almost identical. I mean, now that you said that, I feel like I should pull them up. But I was like, I had not seen the first picture of Lila before I saw the picture. I'm going to pull it up. Before
They're
I
not
saw,
almost identical. It
no,
takes the exact picture and then
I'm going to
it
show you why.
animates it.
That's it. Now I'm going to show
Well,
everybody.
clearly
So,
she had like all her
hold,
grill. She had all her teeth. You knew
hold
from,
on.
like, all right.
Trying to talk some shit now. Just you
Oh, I'll
stop.
talk shit.
Just you stop. Where the hell is it? Wait.
I mean, it comes free with my $50 a month thing on X so that I'm supposed to be able to edit within 30 minutes.
What happened to an hour? It used to be an hour.
I don't know. Like right now it's 0. It's like the 2 posts I put in a row where I noticed that I like today's post, I accidentally put a comma after Kelsey and before Fitzsimmons. I'm like, okay, well, that clearly doesn't belong there. And you know, I couldn't go back in and edit it. I don't know. I don't know. Uh-oh, Mag, you tell your kid that they should always be wearing their earmuffs when they're listening to Defense Diaries in the background, because a bad word might just slip out. We're known to say bad words over here. Ruh-roh.
All right. So here's the wait. Why is this not okay? So I'm gonna open both. Let me do this one first.
Wow, tech wizardry at its
No,
finest.
I'm laughing
Here
because
it is.
I'm laughing because it started to play.
Oh, well, you have to share it, love bug.
I know.
Oh, okay.
Hold on.
Wow, the anticipation is killing me, and probably the audience as well.
All right.
Okay.
So
All righty.
I don't know if
Come
it's gonna,
on,
all
sis.
right, stop. I don't know if it's gonna let me do this because it's in a preview thing. All right. Can I even make it bigger?
Aw,
Oh, yeah.
thanks, Una.
I'm making it bigger. Okay. All right.
Wow.
Hold
But I
on.
want you to prepare yourselves. Our daughter or our granddaughter is absolutely adorable. She's like legitimately. There's always, you have some friends that might have a baby, and you're like privately in your mind, you're like, it's not the cutest baby, but you would never say that, obviously.
Actually,
Our
I'm gonna
granddaughter is
do it this
legitimately
way and
adorbs.
share screen. I got to
All
cover
right,
up.
I'm about to move on.
No, it's too late. Everybody needs to see it now. But I'm just trying to cover up all the other thing on my screen so I can just share the entire screen, because you have to see them side by side. All right, we're gonna do it like this. Here we go. Here we go.
You're
All right.
muted.
Am I muted?
You were the first time you told me to stop.
Oh,
I don't know what happened.
let's see. Which one's the real one?
Oh, thank God.
Okay.
Oh, look.
So this is the
Actual photo.
no, this is your photo. This
Yeah.
is your video photo.
Oh, okay.
So I didn't see the other picture before this. Now, okay, look at the
But I need you
cheeks
to
and the
understand, you literally
eyes.
take the photo and you put it in
All
Grok
right.
and then it
All right.
animates.
Now I'm gonna share the other screen because you're getting all uppity. I'm gonna figure out how to put them side by side, actually. Just decided again.
She's a cutie patootie. There's no doubt about that. Cutie patootie. She's a cutie patootie. All right, Jesus, dude, what?
Just
It
give me
looks
a sec.
exactly like that.
No, hold on.
Oh, bullshit. Like, you're
Okay.
literally the only person who saw this, what you're trying to attempt. Like, none of the older kids were like, oh, yeah, I see what you're saying. No one did that.
I know,
Only
not
you.
even the parents.
You
You
didn't
guys are
even
gonna
play
see.
the video.
Not
What is
playing that
happening?
video.
So what
I don't
was your point?
hold on.
Oh, my God.
How do I
Ermiger.
All right, wait. You gotta tell me if this works, though. Oh, it's not working.
No, that baby was not just birthed, Brie, and it feels like it. No, that was over a year ago. She's had her first birthday.
All right, I can't put them side by side,
Oh,
so
good God. Just flip between the two. Can't you do it like his
it's not letting me, like, doop, doop, like, real quick.
patience is a virtue? Is
All
it
right,
Pete not?
okay.
Oh, there we go.
This is the real baby. I've got to blow her up because if I put them next to each other. All right, is she getting bigger?
She's getting bigger.
Look at her cheeks.
She's
First of
growing.
all, her eyes are not brown as they
She's
are in the other
growing.
picture.
Wait,
She's got
is that the actual picture?
This is the actual picture.
All right, let's see what we got. Now go back to the other one.
All right, it's gonna take a second.
Oh my
All right,
God.
so focus on the cheeks
Focus on the cheeks.
and, like, the adorableness of the eyes. It's close. It's close, but you'll see it.
Okay,
You'll
I'm
see it.
ready.
If they were next to each other, you'd really see it. All right, here we go. I have to stop sharing.
Oh my God.
It won't let me click between them.
Ermiger. So this is our we're giving you all a little break from true
Wait,
crime.
that's the real baby again.
Okay, real baby. Real baby.
One
Okay,
more time.
we're gonna
Here we
do
go.
this.
Here
I
we
feel like
go.
we're winning. Winning. Winning.
All right. And this is
Okay.
the not real baby. It won't let me
Okay.
make it bigger.
Okay. It will not?
No.
Oh, okay.
I don't know why, because it's the movie. So anyway, I can see it in her cheeks. Her eyes aren't brown.
Play the
But
movie.
no, I'm not doing that. Her mother
What?
would not like that. No.
What? It's hilarious.
She's very anti potty humor. And her grandmother would probably have, like, really
Wait,
fall over.
she's anti what?
Toilet humor.
What?
Yeah. They very, very much against toilet humor in the Moore
What?
family. Yeah, no potty humor.
What?
No potty humor whatsoever.
Yeah, well, guess what? Fun Pa gets to override that shit.
Well, you can do whatever when you're
I'll
with her.
do it. You can't stop me. All right, let's get back to wow, that was a lot of waiting and not even playing the video. I'm calling bullshit on it, but whatever. All right. Okay,
And I
so
didn't get to put them side by side, so no one could tell. They all think they look exactly the same.
yeah, yeah. All right. So to
So
wrap up on Robert, look, I
Roberson,
mean, yeah, I mean, I think the biggest takeaway that Texas junk science law is actually super progressive. I mean, it shouldn't be, but it is. But as this case shows, even with that law in the books, even with that law right there for you, it took massive public pressure, political intervention, and multiple execution dates before the court would seriously consider the new evidence. And that is fucked. Not only should Robert Roberson not be being executed, he shouldn't be in fucking prison. Let the man out.
right?
I mean, he's never going to be the same. I mean, like this guy has been on the verge, literally on the verge of the government murdering him on multiple occasions. You just that doesn't just roll off your back and you just keep on trucking.
No.
No,
For now, he remains on death row. Obviously, he's still fighting. So we'll have to follow this case. If it actually returns to trial, I mean, if I'm the state, I'm just dumping it,
yeah.
but we'll
Well,
see.
especially because the lead detective is going to come in and testify on behalf of the defense. It sounds like, yeah, I fucked it. Sorry.
Yeah. Yeah, but you'd think they would have had the opportunity to join in on any one of these appeals that have been going on for,
Yeah,
God knows
this is
how
one of
long.
those prosecutors' offices, like I'm always talking about, that I can't stand, that just die on stupid hills.
Yeah.
That I like it, I'll never get it. Sometimes you get it wrong. There's no shame in that. I have way more respect for any prosecutor, even if it was a predecessor 20 years ago, that says, hey, you know what? We've really looked at this case and we decided as a group that we got it wrong, and we apologize wholeheartedly. Because the only thing that you can think that stops them from doing that, aside from ego, which I don't impute onto predecessors, to the people that are subsequent to the office after them. It's like, how can that ego extend to somebody who had nothing to do with the case 20 years earlier? Is money. Is it the liability side of it? They don't want to have to be paying out $20 million, the county
Right.
doesn't,
Right.
for them screwing up. I mean, it's like, you know
Just
what?
kill him. Just kill the guy. I don't
Just
pay.
execute him. Do you want to pay 20 million bucks? I don't. I don't think it's a good idea. You want to stay in office? We're not getting elected if we pay out 20 million bucks.
We let this guy off death row. They're not going to want us killing anybody.
All right, so let's turn to a case that we've been covering pretty heavily over here, and it takes place in the Commonwealth of Massachusetts. What is going on with Officer Kelsey Fitzsimmons, babe?
So just as a real quick, most of you know, we just did a live on it 2 days ago. So if you want more details, grab that. But she's a North Andover police officer who was shot by a fellow officer who was serving a restraining order. And now she's charged with, what is it? Second degree attempted murder.
That sounds right.
And
Sounds right.
she's 28 years old, and she's fighting her bail revocation / denial of bail on a reconsideration, and the Commonwealth has filed their response.
Wow. So I know we had a little bit of dispute, but of course, as always, Allie wins. You wanted to read through that, at least a portion of it.
Yeah, I
Right?
mean, you're always the one, like, people like when we read it, da 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 da.
I know. But then you told me it was 23 pages, so I was like, oh god. Oh god. But I agree. Let's read through it. Let's see what the Commonwealth kind of bullshit they're coming up with.
Are you seeing the Commonwealth, or are you seeing a different screen?
Yeah, I see it.
Okay, because I didn't know if it was the. All right, so it's the Commonwealth's opposition to defendant's petition. The defendant brings this petition for relief from an order of the Superior Court finding her dangerous and detaining her prior to trial. The defendant was indicted on August 25th, 2025 for one count of assault with a deadly weapon. Oh, so maybe
Oh,
I
they're
made
good.
that
I'm glad.
attempted murder.
That the document actually corrected you, because I was
Yeah.
Googling and I'm like,
I was
doesn't
like,
sound right.
I might be saying, brain fog is real. So although there's no indication, and this is the Commonwealth, although there's no indication that the defendant was intoxicated when she pointed her gun at a fellow police officer, and again, that's obviously a hotly disputed pointed fact here, but who was at her home serving a restraining order, the Commonwealth demonstrated that alcohol fueled the precipitating violence in this case and has been a persistent issue for the defendant. I found it odd there's no citation here. Where's
Yeah.
the citation?
Where's the
Where is the
citation,
citation?
scumbags?
How did you demonstrate this and with
How
what?
was it demonstrated, people?
How?
Tell us.
So moving
Do
on,
it.
recognizing the dangers inherent in the intersection of alcohol abuse and mental health issues, the Superior Court judge fashioned reasonable terms of release, including the condition of submission to a scram device that would deter the defendant from consuming alcohol. And we've described that before. It's a way to they breathe into it, and it basically works like a breathalyzer test. So despite having obtained her release from custody within 48 hours, the defendant was back before the court reporting that she was unable to abide by the scram condition. Therefore, the court reasonably concluded that the only way to assure the safety of the community was to place the defendant in custody. So I don't know if anybody was expecting something similar to what we saw in Richard Allen's case, where you've got, I can't remember if that's the attorney general, I think it is, saying, yeah, we need all this shit. No, this is what you typically get. And that is the judge is right. The judge is right. The defendant is wrong. The judge is always right. So they go through the procedural history, and I think it's just interesting because it tells you like what their perspective is. So complaint was issued July 3rd, charging the defendant with assault with intent to murder and 2 counts of assault with a deadly weapon. The defendant was arraigned August 7th, 2025, and after hearing was ordered held, so without bond. The defendant appealed the determination of the dangerousness to the Superior Court on August 14th, 2025. And the court conducted an evidentiary hearing. 1 day later, Judge McCarthy issued a decision upholding the finding of dangerousness and the conclusion that there was no condition of release that could safely permit the defendant's release. Notably, the court found that it, quote, has not been presented with a satisfactory release plan. On August 18th, 2025, the defendant filed a renewed Superior Court bail appeal with comprehensive release plan for reconsideration, which the court denied on August 25th, 2025. They did not want to let this woman out. So footnote 3 says, I was expecting you to like back me up on that, babe.
Oh, I got your back, girl.
You just left me all excited and hanging.
I got your back at all
So
times.
footnote 3 says the Commonwealth recounts the history of the case starting in the district court to highlight the familiarity Judge McCarthy had with the case even prior to the Superior Court dangerousness hearing. So back to the body. That same day, the defendant was indicted for assault with a dangerous weapon. The grand jury having returned a no bill on the proposed indictment charging armed assault with the intent to murder.
Rejected.
Right, but that didn't stop the Commonwealth from trying. I think that's what I was remembering. I knew that.
Oh, sorry. That was the Commonwealth train of prosecution.
Oh,
Prosecution train has left the station. Yeah. Right,
but I knew that they were trying to get her on a murder count. So anyway, the defendant was arraigned and the Commonwealth filed another motion for detention pursuant to their statute. A lengthy hearing was held on August 28th, 2025, after which the court found the defendant dangerous, but concluded that she could be released with conditions, including GPS monitoring with home confinement, except for medical and legal appointments with 48 hours notice to probation, and no use of alcohol with monitoring by the scram device. The defendant's release was stayed pending a satisfactory home visit by probation. When probation returned an unsatisfactory result, the court held another hearing on November 8th, 2025, at which point the issue was resolved and the defendant released. Before the November 8th hearing ended, the defendant requested that the GPS condition be lifted the following day to allow her to undergo a medical procedure. However, the defendant submitted no evidence in support of her motion, and the motion was denied. That was another just ridiculous thing. They knew she was going in for surgery, so she just wanted to get the bracelet off. You know, when you go in for surgery, they're like, don't come in with anything metal.
Yeah, don't
don't
eat
do
before.
right.
Don't drink liquids.
And they're like, well, no one has told me. There is no evidence that she can't do this without it on. But what the fuck are you so concerned about if she takes it off? She's going in for a procedure. I think it was like a surgery to get some, to get some of the, I can't remember what. I'm sure someone in the chat knows. But they denied it. And luckily she was able to do it with the damn thing on. But 2 days later, the defendant filed an emergency motion for immediate relief from scram order, supported by affidavits from the defendant and her mother, and with accompanying.
All right, now I'm gonna. Who can remember a movie? And this isn't for you, babe. Who can remember a movie where the actor or the character had a hard time saying accompaniment, and he ends up changing it to a different word because he had a hard time spitting that out?
Oh, I know.
I know you know. That's why I told you not to blow it. This is one of our Easter egg movie trivia questions that I like.
We've referred to this movie on multiple occasions.
Multiple occasions.
So with an
Shannon,
accompanying
wrong.
email, but you keep an eye on it. I'll keep reading. Email from the probation department. The court held a hearing on September 11th where probation officer testified about the scram procedure.
Ding,
and
ding. Afton nailed it. Afton nailed it. Afton nailed it. Afton wins huge prize. Oh, sorry, babe.
Of Bob's great
Jingles.
No, yeah, jingle. But you're, what's the word when you're not adornment, but
Yeah,
that's his prize. Is that you?
Yeah, my excitement over somebody getting the trivia question correct.
Yes.
I'd say the preponderance of my movie trivia questions, Afton's typically the first or second person. So Afton is clearly.
And it's not one of those things you could have Googled. It's not like Googleable. They're not like
Afton
yeah,
knows.
That's
Afton clearly
right.
knows.
Mm.
Clearly. Well done, Afton.
Well done.
Well done.
It's one of the only musicals that Bob likes. So.
Yeah.
He's like, don't get everybody started on me.
Don't get everybody on that fucking musical thing, please, for the love of God. For the love of all that is sacred.
The man loves music, hates musicals.
Any of you boys Smitties or otherwise trained in metallurgical arts? Yeah.
All right. So
I don't want FOP, goddammit. I'm a Dapper
Dan man.
Yeah, come on, dude. So many great quotable moments. All right. Keep going.
So,
I'll through.
I mean, it's a long thing.
I know, man. Believe me. I know, sis. I know.
I guess we're changing roles here because that used to be me. Are you gonna read the whole thing?
Well, I'll help you read some of it.
No, I'm just saying.
I'll
skip over some parts. No, I mean that it used to be me being like, you don't need to read the whole petition. Just tell the people about it.
Yeah.
And then people are like, let him read.
Yeah.
We like it when he reads.
Did they make that face too?
Yes, they did.
Wow.
So anyway, the court held a hearing on September 11th where the probation officer testified about the scram procedure and the defendant's apparent difficulty breathing deeply. At the conclusion of the hearing, the court removed the scram requirement because she did not want to, quote, torture the defendant and remanded her to custody. Before the court could issue its 5-page written order later that day, the defendant filed a motion to reconsider. The court denied the motion to reconsider in an 8-page order on September 16th. The defendant filed the instant petition without the evidence submissions from the various evidentiary hearings, the court's written findings, and or an available transcript. Well, I thought they specifically mentioned stuff and audio. Maybe they just did the audio, not the.
Apparently, Melanie has some 911 reports that are interesting. We haven't gotten our hands on those. If we get our hands on them, obviously we'll cover them. I also, Mag, I see you. I definitely want to read the new Scott Peterson filing by the the LA Innocence Project because
Oh yeah.
I definitely want to read it
I
because
just
that's
want them to
why.
make a documentary on it so I can watch it.
Oh wow. Oh wow.
It's
Lazy
gonna be
much?
it's gonna be long, and then I'll forget it halfway there. What did I read?
I'll
By
probably
the way, for
say there
anyone out
wasn't
there
there's a
interested,
T. There's not a T in his name. It's Peterson. Peterson.
what?
I'll do the
It's
thing I did
Peterson
with. I know. I'll do the thing I did with Roberson,
in reverse.
where I added a T.
Anyway, I was saying, for anyone out there wondering, my brain fog clock has reset, so we got another year at least. So yeah, fun.
Hot
Um,
fun in the. All right, sorry.
oh Lord, not happy.
Happy for Lana. We're gonna cover it too.
What?
Scott
Happy for
Peterson.
Lana. Why is that?
Somebody said Lana was covering. It's
Oh.
cool. That's cool. That's cool.
All right. So I'm just surprised because you're supposed to have the the docket and all the exhibits, just like you saw if you followed us with Richard Allen, where they're like, no, we need the record. I mean, it's the job of the person petitioning the court to have the record there, and you would most certainly need
Oh my God.
what?
This.
I'm reading on a different page, so I'm not
No.
even
Carrie
see
said
what.
that perimenopause can last 10 years, Allie.
Stop it, Carrie.
What
You're
the
out of
fuck?
here.
What the
No.
fuck?
No.
Oh my God. No. No.
I mean, you'd be really old still getting your period at like 60. But I mean, I don't know if she means actual perimenopause. So my understanding, perimenopause is a year after your last period, but that doesn't mean your perimenopause symptoms won't just turn into menopause symptoms anyway.
It
So
seems like Allison just rocked me to my core when she said it restarts. So if Allie hasn't had her period for a long time, we're like, oh, menopause here, and then boop, it shows up. I'm like, wait, you're saying that perimenopause fucking restart, like the clock restarts? I'm like, no, man, no. She
yeah,
has a really hard time remembering shit. It's true. It's crazy. It's like there was an example today. I'm like, what? You said something that was crazy. I'm like,
all right.
what?
Yes, while you're in perimenopause, you still get your period. You have to not have your period for a full year
Wow.
to be in menopause. So,
Dang. That shit's crazy. That is crazy. You should ask for a refund from the refund office on that whole menopause shit. Listen.
Hey, I have it a lot easier than so many women. Like the brain fog and hot at night is nothing compared to what a lot of women get.
I wouldn't say the brain fog is not nothing.
I mean, but some people get that. And you remember what our close friend said about feeling like hot lava was.
Oh, the hot flashes?
Yes.
I thought was that pre-menopause, perimenopause, or was that actual when she's in menopause?
I can't remember.
I thought she had menopause.
No, I think she was perimenopausal as well.
I don't know. You'll have to text her.
I mean, I don't know that goes away when you're all right, let's get back on track. It was supposed to be like a quick, nod to those who knew, and then it turned into a whole conversation. I just wanted to say my brain fog clock started over again, and everyone who needed to know knew what it was. Okay. So, the defendant filed the instant petition without all those things. Later on the day of October 3rd, 2025, and filed a supplemental exhibit on Monday, October 6th. The parties were in court for a pretrial hearing on October 7th, and the next court date is November 25th for scheduling of a trial date. So now, this is the statement of facts, the way the state, the Commonwealth, is putting forth. They've got their first footnote right at the title here. And it says the facts set forth here are detailed in the police report that was part of the evidence submitted during the dangerousness hearing. So you want to do the facts? You want me to do them?
Sure, I'll do them. Seems like you're whipping past them.
I was trying to see how long they were. Okay, they're not long at all. This is what I think the people are going to find
The people,
most-
the people.
most interesting is the state's version.
Yeah.
Because we've been saying like, what, what's the
Yeah, let's
state?
see if they mention the fact that she had postpartum depression. Let's see. Like I haven't seen or heard anything about that part of Kelsey's reality at all in this pleading. So, all right, contrary to the defendant's claim, the facts of the underlying allegation are hotly contested. At least they acknowledge that. At approximately 6 p.m. on June 30, 2025, Lieutenant Sean Daly, Officer Patrick Noonan, give me the movie. Somebody give me the movie. And Officer Timothy Houston of the North Andover. Oh, wait, hold on. It's hidden.
Wait,
Police Department.
are you not looking at me? I'm not scrolling this for you.
Yeah, you are.
Oh, okay, sorry.
Like a portion of it was hidden because I had a super up on the screen or something on the screen. The North Andover Police Department responded to 125 Phillips Brook Road to serve the defendant with a restraining order. The defendant, a North Andover police officer, resided at 125 Phillips Brook Road with her fiance, Justin Elaine. How do I say? Somebody tell me how to pronounce his name in the chat so I don't have to keep butchering it.
Elaine.
I'll just Elaine.
Justin Ilion.
So nobody's like, usually you guys are real good. Let's go. How do you pronounce it?
They like Ilion for
I'm
Justin.
just going to call him Justin. That's the
or
that's
Ilion.
There you go, Jen Toxic. Exactly. So, and their 4-month-old infant. Earlier that day, Justin had sought out and was granted an abuse prevention order out of Essex Probate and Family Court. Justin alleged that the defendant physically assaulted him over the previous weekend and that he was in fear of her and for the safety of his child. He stated the defendant had assaulted him in the past and feared that the defendant would hurt herself and the child if he were to leave. Along with serving the order, the officers intended to remove the defendant's firearms from the residence and transfer custody of the child to Justin. The officers informed the defendant about the restraining order, advising her that she was thus required to relinquish her and give Justin the baby. It sounds like they skipped firearms. Yeah. And give Justin the baby. The defendant told the officers that her firearms were locked in a safe in the basement. Approximately 10 minutes after the officers arrived at the residence, they called Justin to gather his belongings and take custody of the infant. In anticipation of Justin taking the baby, the defendant began to gather items, example, clothing, diapers, bottles, from around the house. Officers Houston and Noonan escorted her between the rooms. After gathering bottles and diapers on the first floor, the officers escorted the defendant to the second floor so that she could gather baby clothes. Now, while they were on the second floor, Justin and the defendant's mother arrived at the home. When the defendant heard Justin, she asked Officer Houston to keep him away from her. To maintain order, Officer Houston left the defendant and Officer Noonan on the second floor and went to monitor Justin as he gathered belongings in the basement. Scroll up, babe. Lieutenant Daly remained on the first floor with the defendant's mother, Justin, and Officer Houston. Minutes later, he heard Officer Noonan on the second floor yell, "Kelsey, don't do it! Kelsey, don't do it!" Followed by 2 gunshots. Now that right there
sounds like she was going to shoot herself.
Like she was getting ready to shoot herself. So he ran upstairs.
Wait a second. I just want to note because
followed by 2 gunshots. Yes.
Right. Didn't he just say
yes.
Oh, okay. I thought that the one guy just went back, like that he had left and then went back. So no, he stayed there all the time. All right, sorry.
Wait, you went down a little too far.
Oh, sorry.
Okay, so Kelsey, don't do it. Kelsey, don't do it. Followed by 2 gunshots. He ran upstairs and rendered first aid to the defendant and requested an ambulance to the scene. Lieutenant Daly observed a firearm where the defendant was lying and moved it next to the bed out of reach of the defendant. Footnote 5 states Officer Houston also heard Officer Noonan scream, Kelsey, followed by, is there more to that? Like you've got
No.
Kelsey. So that's all he heard her scream? Just
Right.
Kelsey, followed by 2 gunshots. So I already have a discrepancy there with these 2 cops are. Like Kelsey's a lot different than just Kelsey, don't do it. Like that's what you'd say if somebody had a gun pointed at their head. I mean, I
Right.
guess you could say if they have it pointed at you too, but like the first thing that popped in my head. So Officer Noonan explained that while that he was briefly alone with the defendant on the small second floor. The defendant was kneeling on the floor in her bedroom while folding laundry for the baby. While standing in the doorway, Officer Noonan observed the defendant face him, lunge behind the door, and reappear, pointing a firearm directly at him. The defendant pulled the trigger, and he heard a click, but no round fired. So now I saw somebody in the chat said that when Melanie was going through the 911 calls, that there actually is no door. Where they just stated that she dove behind a door, got the gun, and then reappeared. Somebody in our chat is saying that there is no actual door in that particular room or area. So take that for what it's worth. Okay. So yeah, the defendant pulled the trigger and he heard a click, but no round fire. The defendant began to stand up as Officer Noonan pulled his firearm out of its holster as the defendant attempted to rack her firearm to chamber a round. Officer Noonan gave several commands, including drop the gun and don't do it. Believing that she was trying to kill him, Officer Noonan fired once as the defendant continued trying to chamber a round. Officer Noonan fired. Up, please.
Oh, sorry.
So we got that due process thing there that blocks some words. Officer Noonan fired a second round, striking the defendant.
I mean, here's the thing with these facts. Like I hadn't heard this outright, like the way, I mean, I know that they said that he pointed the gun at her, but hearing the way he's describing it now.
So wait, did he miss with the first shot? Because the first, he says he fired 2 shots. I don't remember hearing
had a
that.
lot of
believing she was trying to kill him. Noonan fired once, apparently missing her, as the defendant continued trying to chamber
No,
around.
I think he hit her, but maybe not in the right.
Well, then why doesn't it say, like it talks about with the second one, Officer Noonan fired a second shot, striking the defendant?
Yeah.
I disagree with you, ma'am. It seems like he shot and missed.
I mean, one of them, if she is denying the first pointing with the gun not going off, I mean, one of them is just outright blatantly lying.
Maybe the first one was a warning shot. You know what I mean? Hoping that she dropped the gun and be like, all right, whatever. I don't know. Huh.
Right.
All right, what are we doing next on this bad boy here?
So they go on to say that they submitted an affidavit at the August 25th hearing. I mean, a police report and an affidavit filed in support of the restraining order filed in the probate court. Now, this affidavit would be by Lion. So he outlined that
see what you did there. I see
the
what you did.
Defendant was heavily intoxicated and physical with others during an incident in Maine on or about June 28, 2025, which was described as the defendant's bachelorette party. Now, someone in the chat has to tell us they actually did have affidavits from other people, from her friends that were at the party that corroborated some of this, right?
Yeah, let us know. Let us know in chat. Were there, because I don't know that this ever made it to a full, like what we call a plenary hearing, but we would like to know if there were affidavits that were attached to this from other witnesses, because if it wasn't fully litigated at this point, his allegations are just that.
Right.
I'm talking
But
about Justin.
Bob thought he remembered there being some
I thought I did. So I thought it was statements from some of Kelsey's friends or their mutual friends. I don't know.
so
Plenary, not plenary. Plenary.
so
Boogs doesn't like plenary.
that she was heavily intoxicated in physicals with others
No
at a bachelor
affidavit,
party.
Melissa says.
No other affidavit, just his?
Yeah, apparently.
Okay. So that's what Lion said. As the 209A order was issued from the probate court, a judge found that there was a substantial likelihood of immediate danger or abuse to Justin. The materials submitted by the Commonwealth also include a written statements made by Justin and other people who were present during the incident in Maine on June 28th and the incident on June 30th. Throughout these statements, witnesses describe the defendant as intoxicated, drinking heavily, and engaging in aggressive behavior towards numerous individuals during the June 28th incident. The statement also references prior similar behavior by the defendant. The defendant argued that she should not be found dangerous and moved that she should be admitted to personal recognizance or reasonable bail under the bail statute. Defense counsel submitted reports from and it says a doctor of psychiatry service at Massachusetts General Hospital and another doctor who's a licensed forensic psychologist. Based on the material submitted by the defense counsel, the doctor opined that the defendant no longer met the Section 12 criteria, so she was no longer harmed to herself or others, and is appropriate for outpatient care once medical stabilized discharge. Through their motion, defense counsel requested that the court, quote, issue appropriate orders in the interest of justice set forth above. So you have footnote 6, and it says, however, as Judge McCarthy noted, the defense did not submit any documentation regarding the defendant's medical condition as part of the dangerousness hearing. Not a single medical record or affidavit from a treating physician were submitted in either the district court dangerousness hearing nor the superior court hearing. As part of their piecemeal litigation, defense counsel filed a, quote, medical notice to the court on September 5th, 2025, which was simply a filing by defense counsel and was impounded by the court. After argument from the Commonwealth and the defense, the judge found that the defendant was a danger based on all the above alleged facts, her history, her mental illness, We all know what happened. She said that because this is before that. Okay. That found that the defendant was a danger based on the above facts, her history of mental illness, and the defendant's own out-of-state record, including public intoxication and disruption, but that there were conditions of release that would provide the necessary protections: the GPS home confinement, residing with her mother and stepfather, compliance with mental health treatment, and abstaining from alcohol with scram testing. However, the defendant's release was stayed pending a satisfactory home visit. After reviewing the Kari report of the residence of the defendant's proposed release, the court ordered further hearing. On September 8th, the court released the defendant according to the previously ordered conditions. Footnote 7. So it says the defendant finally filed a letter signed by a medical doctor on September 15th, 2025, well after the defendant had been remanded to custody and after the defendant filed a motion to reconsider. The one-page letter summarized the defendant's injuries and supported the claim that deep breathing may be painful, but did not indicate that deep breathing would hinder the healing process. That was something else I thought should be in there, that it could that it's could be more than just painful. Contrast D petition at page 2. They're talking about the defendant's petition, where the defendant reported that, quote, she could not use the device without great pain and aggravating the healing of her broken ribs. That was actually the rest of footnote 6. That was a continuation of footnote 6, where what defense counsel had requested. So footnote 7 is defense counsel characterizes this judicial oversight of the location of the defendant's release as micromanaging the release plan. The Commonwealth suggests that this laudable attention to detail and is understandable, where Superior Court judge makes a determination to release potentially violent and mentally unstable defendant into the community. And he cites back to the defendant's petition at 4. But before the hearing even ended, the defendant sought an order to relieve her of the GPS monitoring. We went over that because of the driving. Then they talk about how 2 days later, she claims she's unable to do the testing, that it was physically impossible. She couldn't do it. The court held that hearing and made it abundantly clear its perspective on alcohol testing. When defense counsel framed the issue as, quote, a simple adjustment of terms, the court disagreed. I don't see it that way. I'm telling you, it's not a simple adjustment. One of the reasons she was released and one of the reasons to ensure the safety of the community was for her to be alcohol free. If she cannot do that or will not do that, that changes everything. And that's a direct quote from the judge. And that's she said that early on when he did call it a simple adjustment. And that's where I've always said that's where you take a cue that this is not as simple as I thought it was. This is about to not go the way I wanted to. And I need to tell the judge now I need time to get some more things together. And, you come up with something on the fly,
Yeah.
Defense counsel argued that although the defendant could pass the test, it was with, quote, difficulty. At the court's direction, PA January was sworn, and he described the defendant's prior day's performance on the Scram test and informed the court that the tests were conducted at scheduled times. Again, footnote 8, that the judge indicated that she was surprised that this testing was not random and the defense was apprised of a testing schedule. And we all know that the judge was like, I said it had to be random. And the probation said, we always do it this way, Your Honor. So, whatever. So he also observed that the defendant appeared to be, quote, in genuine pain during the setup process. And for that reason, did not believe that the failure to complete the scheduled tests were willful violations of probation. The court also accepted the defendant's Scram history as evidence. The Commonwealth presented no evidence, but reiterated how important that the Commonwealth's belief is, in light of the court's releasing the defendant, that the testing be done. After confirming that the defense had nothing further to present, the court heard argument from defense counsel. He reiterated that the test was only possible with significant pain and dizziness and having to recover for several hours. He argued that there were other ways to do it. If the court wished to have her tested for alcohol or for the lack of alcohol, that's completely fine with the defense. But just the means that are employed is kind of a torture device for her, cruel and unusual punishment, and a potential Eighth Amendment violation. However, the defense did not offer any specific alternative methods of testing. The court took a recess before issuing the decision. Now, look, I understand that different lawyers are going to have different opinions. I also understand that a lot of this is common sense. The judge could take judicial notice of certain things. She knows what kind of testing is out there. The reason I harp on this is, again, because of that quote that they just put up above, where the judge showed her hand. I'm about to screw you. I don't see this the way you did, and I'm coming for you. Basically, is what she said. So that's when the lawyer should have changed gears a little bit, in my humble opinion. So the court took a recess before issuing a decision. Then she said, I have reviewed everything again that's been submitted. I will state for the record, Fitzsimmons has moved twice in 3-day period to amend her conditions. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community to the general laws. Just days ago, the court concluded that the condition of remaining alcohol-free and submission to Scram monitoring was necessary to ensure the safety of, and she just goes on and on. Oh, you're saying it's
blathering. I like to say
you're
blathering.
saying it's torture, so I have no choice. And without this condition, that there's nothing I can do to assure the safety of the persons in the community, and she vacated it. Now, all that being said, oh, you had no medical records. This was a process. They had to put off like arraignments and the first bail hearing because she knew she's in the hospital, that she was on breathing support, that she had diaphragm, like all sorts of injuries. Somebody pointed out in the comment on our last live, one of the injuries that we forgot to mention. I think it was the diaphragm, but she had very serious injuries, and the court was fully aware of those things. So I'm still taking issue with the judge. I don't want anyone get it twisted. I take issue with the judge. I take issue with the judge pretending she doesn't know shit she damn well knows. I'm just saying, when you run up across it, when you come across a judge who you know is about to screw you, you take a second and you reassess how you're going to go forward.
Yeah.
And then footnote 9 says, although the defendant disparages Judge McCarthy in his petition, okay, and attempts to characterize her behavior as injudicious and short-tempered, the transcript reveals that she presented the defendant with every opportunity to present evidence and make argument. And I kind of think she did give him every opportunity. That she did do. Every opportunity to present evidence and make argument. She kept asking if he had anything else. He said no. After a recess, she issued her ruling from the bench and concluded the hearing. It was defense counsel who interrupted the judge, yelled to the bench after the hearing was concluded, and had to be chastised by the court officer for swearing. Wait, where's the rest of that? Or was there just no period?
I don't know. Maybe it was such bullshit that they decided not to finish it. Oh, the period's after.
Period's there. Okay.
Yeah.
Sorry.
Throwing Bradle under the bus, pulling an alley, swearing at the judge. Ooh, you and Bradle sitting in a tree, swearing at the judge. Oh, just kidding.
That is not true.
Oh boy.
Judge McCarthy issued a written order later that afternoon. But before it was docketed, the defendant filed a motion to reconsider, asking the court to release the defendant and order alcohol urine screens at a private facility. The defendant supported the motion to reconsider with an attached email from probation officer January from September 10th, in which he had responded that the only alternative to scran testing was urine screen at a probation vendor.
Yeah, no, and I agree here with Becky RN. The transcript in no way, shape, or form matches the tone and tenor and the timing of the audio. It's like that.
I was actually gonna.
Judge was coming in hot.
Yeah.
I mean, she was not an agreeable judge at all. Like you'd know, again, it's that thing. Is she always shitty like that? She'd wake up on the wrong side of the bed.
But in her shitty way, she did give him a chance to get this shit on. And the
thing is, he had I thought the probation officer was very, very effective in terms of what he was saying, especially when you come down to the point of look, we're not asking for rescission. We would never have Your Honor, would not have even been aware of this as a violation because we don't consider it to be a violation because she was able to blow a little bit later down the day. But
he could have asked him right then and there about the alternatives, and he didn't. He kept wanting to use the email. The guy was right there. He's already talking.
Yeah, that was weird. It's weird.
I mean, I don't think it would have made one bit of difference because
he might know that probation office doesn't have an alternative at its disposal.
Well, it's got the urine testing.
Yeah.
But we know that wouldn't have done any one shit bit
of difference.
That
wouldn't have done shit.
Right, because the judge doesn't want her to leave the house. She wants her on home confinement. Again, you and I talked about this 2 days ago. She's on GPS monitoring. What the fuck does the judge give a shit if she goes to a vendor to get tested? It's not unusual that people go to probation, and I don't care what they say about screening at a probation vendor. They could come to the house and take urine. I don't care if they don't usually do it. They can do it to accommodate somebody who's got a medical issue. So anyway, Judge McCarthy denied the motion to reconsider indicating that there is nothing in the motion that was not known to the defendant or her counsel when this matter was last heard before the court. There's been no change of circumstances or newly discovered information that would warrant revising it. The court reasonably, so, that's what the Commonwealth says, reasonably concluded that the defendant's failure to transparently provide information relating to her ability and willingness to abide by the condition imposed despite 3 lengthy hearings is a manipulation of the court's efforts to fashion the least restrictive conditions of release. Bullshit. And it was also known to you, Your Honor. You knew how injured she was. You knew about all of her injuries, and those injuries necessarily just imply she's going to have some difficulty breathing. Again, we talked about this on the 10th. She did not know until she tried just how damn difficult, meaning painful, it was going to be, lasting
Now, how
4
can
hours.
you know what you don't know?
Right. Right.
It's that simple.
So, bullshit, Judge McCarthy. Judge McCarthy noted that the defendant's deliberate decision not to present the alternative urine testing through a private vendor through testimony of the probation officer, and this part is a quote, at the hearing on September 11th, the court gave, it's not a quote. At the hearing on September 11th, the court gave the parties ample opportunity to present their arguments. Mr. January was present and testified under oath for the same reason. Rather than bringing the alternative testing to the court's attention and inquiring about it with Mr. January during his testimony before the court, defense counsel at that time sought only an order completely relieving the defendant of her condition of release, requiring her to submit to scram monitoring, which is not accurate. Footnote 10, Judge McCarthy also noted that the proposed alternative, which was not supported by testimony from the probation department, would significantly alter the home confinement condition. What is this guy talking about? In no way, shape, or form did they say that they wanted her to not be relieved of her condition of testing. They said, we don't care what the alternative is, any alternative. It's just this manner is not working. I agree. They did not specifically have the guy testify about the available alternatives. They, for whatever reason, were trying to put it in through the email. I don't know why anyone's calling that,
I mean, the judge, if she was so inclined, certainly could have asked the PO what else is available when he was testifying.
Oh, hell no, because you already knew what she wanted to do.
That's what I mean, but I'm saying in reality, she didn't do it, but she could have.
Right, and she didn't do it because she didn't want to release him, and it's the defense's job to do, and she is about to slam him with him not doing it. Again, it was weird. The prosecutor said the words, when the judge first said, an email, counsel for Commonwealth, what do you say about this email situation? And he was like, well, it's not a big deal. Plus, the guy is here, so I don't think it's an issue. Meaning the guy's here to testify about it anyway, assuming that the defense was then going to ask the guy about it. But I don't think it was a manipulation. It's the same damn thing that's in the email. So anyway, I call bullshit on that as well. On October 3rd, 2025, the defendant petitioned this court, but failed to provide the court with the documents necessary to present this court with a complete picture of the lengthy 58A litigation. So again, they're complaining about that. So, and then the rest is argument at the end of the day. Should we summarize it?
I mean, if you want to.
So,
I mean, my summary is that it's bullshit. Yeah, because like the one thing that I want everybody to remember is that when this thing was set for the hearing, the day in which the judge threw Kelsey in, there was no ask on the behalf of the Commonwealth. There was no request. There was no motion filed. There was nothing existed from the Commonwealth of Massachusetts seeking to have her thrown in jail or seeking to rescind her bond. So that didn't exist in the world. The judge did this on her own accord,
Right.
and you see a very different tone in this response than you've heard from, which is one of those frustrating things for me.
Right. And
It's like,
they're go ahead.
now
Sorry.
all of a sudden, now that she's in custody, now you're fucking good with it. Come on, man, you're full of shit. Like, if I'm having a discussion with any of these DAs or ADAs, I'm like, dude, you didn't give a fuck 2 weeks ago. Now you care? Like what gives, bro? What gives, sis? Like what's going on here, man? Like what are you doing? Because it's just they're talking out of both sides of their mouth. Because like they're fervently fighting from her getting out of jail. Like, you know what I mean? Like they're putting forth like a real, the old college try to here to keep her in. So
They got to back their judge.
yeah, I guess.
So their point one is just conceding that this is the right avenue to take it to the Supreme Judicial Court. But their second point here is complete bullshit. The defendant's actions, which are alleged actions that she remains innocent of, in pointing a gun of a loaded firearm at a fellow police officer and pulling the trigger, coupled with an admitted history of mental health illness. So that part is actual. But then you have alcohol abuse, which hasn't been established, and amply supported the lower court's finding as to her dangerousness. You've got established alcohol abuse at an ex parte hearing, right?
Yeah.
I mean, she wasn't there.
Right.
So there was nobody contesting what Lion was saying.
Right. Just in there telling tales, talking shit, saying things. And any judge that sits on the bench that's ever, had the opportunity or the misfortune, however you want to look at it, of being the one to rule on these petitions for temporary restraining orders, they know. I mean, I think that judges in those situations tend to err on the side of caution just because it's easier. And at least in Illinois, there's a short period of time from once the temporary order is issued to when they've got to be back in court with the respondent being able to respond in kind. And that, I think oftentimes, short of them not meeting whatever the statute calls for, but if they're able to do that and they have a story that's, again, going unchecked, being told to the judge is gonna be like, all right, well, like, I don't want to deny this, and then something fucking horrible happens, and then it's on me because I didn't grant the thing. But like I've said a million times, a piece of paper ain't stopping anybody from doing anything that they've got their mindset on doing.
This to me was huge. Okay. So this is your state narrative. You know exactly what they're going to say. As an initial matter, Judge McCarthy's reasonably concluded the defendant was a danger on August 28, 2025. With respect to the facts of the charged offense, from the outset, the defendant lied about the location of her guns, an apparent attempt to lull the officers into a false sense of security. She then pointed a loaded firearm at the fellow officer, pulled the trigger, and repeatedly attempted to load more bullets into the weapon when the first shot did not fire. So they have her, like premeditating this shit, lying about the guns to lull them into a false sense of security so she could jump out and shoot him. So that's the state's narrative.
Okay.
State's narrative. So he's saying that she was supported in finding of dangerousness, but you can't just rely on the charged conduct that is alleged, again, that she is innocent of. Was a police officer, a correction officer. All those factors get considered. But let's even assuming that the judge did make a finding of dangerousness and that was a reasonable finding. Let's just assume that, because they give judges a shit ton of deference. Maybe even if they were to say that, you still got part 2 of this about reasonable alternatives. So he goes on to say that the judge recognized she has a history of mental illness. Lion wrote, so the boyfriend wrote, that she had been recently sectioned by Lawrence General Hospital, and the defense acknowledged a history of postpartum depression and suicidality. So the defense's acknowledgement that that's actually established. What Justin writes is just words. Them just words, right?
Them's
babe?
just words. I mean,
So
100%, they're just words. That's what I'm saying. Until you have the actual hearing where people have to testify and be cross-examined, and you can test the stories and, you can see if there's evidence that exists. Otherwise, it's just words.
right. So the Commonwealth is arguing that the judge, under these circumstances, properly found by clear and convincing evidence that no condition of release would reasonably assure the safety of another person in the community. And they cite Mendoza case for the proposition that constitutional attack rejected as to 58A detention. That's, again, the finding of dangerousness for denial, detention, pretrial detention, predicated on a defendant's history of threats in the context of evidence of his psychiatric hospitalization, drug dependency, and suicidality. There was no history of threats here. There is no history of threats. And it says history of threats in the context of evidence of his psychiatric hospitalization. That's postpartum. Postpartum. It has not. One has nothing to do with the other.
Agreed.
So then they get into the scram condition, and that the judge felt that was necessary. And they go on to say that despite the defendant's cavalier approach to removal of the condition and her persistent view that alcohol was not part of the incident in any way, Judge McCarthy justifiably found that the, quote, monitoring the defendant for alcohol use with the scram device was critical to the court's decision for release. So the precipitating events over the weekend of June 28th that caused Justin to obtain a restraining order were fueled by alcohol. He reported that the defendant was heavily intoxicated and that she refused his request to stop drinking. The defendant's childhood friend corroborated that the defendant had been drinking on June 28th and that her actions that night were erratic and violent. So there's what you were thinking about, Bob.
Yeah.
The friend further stated that the defendant had struggled with mental health issues, aggression, and alcohol abuse previously. Finally, the defendant even has out-of-state criminal charges that reflect issues with alcohol, intoxication, and disturbing the peace. They went to footnote 11. The Commonwealth could not locate a copy of the defendant's CARI, that would be like the criminal history, in the court file, but the record reflects that Judge McCarthy had a copy during the hearing. The copy is included in the record of appendix. So now the appellate court has it as well. Finally, the defendant even has, I said that. Okay. Where alcohol is so clearly intertwined with the defendant's ability to control her behavior, the court's insistence on scram monitoring was eminently reasonable. Look, change that to say the court's insistent on alcohol monitoring by whatever fucking means. It doesn't need to be scram. What is wrong with these people?
Who are these men?
I mean, believe everything they say and accept their version and say they're even legally accurate. Say whatever you want. This wording needs to be the court's insistence on alcohol monitoring, alcohol testing, or, compliance with the requirement of no alcohol, is reasonable. Not scram. Insisting on a certain testing, I'm sorry, is not reasonable. Absolutely not reasonable, especially when you're like, no, I want her under house arrest. And this other reasonable method has her leaving the house to get tested. So the fuck what?
Yeah. I mean,
She's
and on top of
GPS
it, there are
monitoring.
zero allegations that she was intoxicated at all at the time of this incident. I didn't hear any of your typical,
No, they admit that. They admit
what?
that.
What? They admitted
That
what?
there's no evidence or allegation that
No, but that's not my point. My point is the
Right.
incredible push for scram when that has nothing to do with this incident. Nothing.
Right. It's one of the reasons that undercuts the judge's focus on it, especially by that specific method. So the motion to remove scram condition. So the defendant's motion to relieve her from scram requirement triggered reconsideration by the court. So this is also something we talked about on our live 2 days ago, that the defense keeps framing this as a revocation of her bail. And the state, which they're doing here, same thing the judge did, is trying to call it a reconsideration. And we're saying the statute says that if once someone is released, to get them not to be released anymore, you got to go under 58B. And that's that whole, well, there's also the ability to reconsider when circumstances change. But in the same way the defense knew about her medical issues, so did the judge. So she can't have it both ways, that this is new evidence that she hurting. It's so painful when she does it. It's so painful for her, she can't do it, but pretend that the defendant was being manipulative by not admitting it sooner, when the defendant wouldn't have known it sooner until she tried to do it. So in any event, not revocation pursuant to 58B as claimed by the defendant. And then we go to footnote 12. The fact that Judge McCarthy specifically rendered her decision pursuant to 58A. Again, you can call, a bird a duck. It doesn't make it a fucking duck. Okay. So then they quote section 58A4. So this was the whole thing we talked about in the last live. Specifically permits reconsideration of a prior detention order where there has been a material change in circumstances. And they cite to this case where a hearing was reopened by the judge at any time before trial if the judge finds that the information exists that was not known at the time of the hearing, or that there has been a change in circumstances, and that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of the community. Look, at the end of the day, I think that the appellate court's going to buy this. They're going to consider this newly discovered. So, but it also takes away from their argument that she was being manipulative. So even if they find it newly discovered and that she could reconsider, she still has to consider the alternatives. She still has to consider the alternatives under either section. She has to consider the alternatives. And she didn't. And if she did so unreasonably, in my opinion. She abused her discretion by saying it has to be scram as opposed to something else. And that's what I hope the court decides as well. On September 11, 2025, after learning about intense pain caused by the process of the scram testing, Judge McCarthy became justifiably concerned because she did not intend the condition to be punitive. So they're biting on the defense's words. Like, this is cruel and unusual punishment. You can't leave her in this such agony. And then the judge is like, oh yeah, I mean, I didn't want her to be in agony. So I'll forget it. Forget scram. You're going back in.
You're going in.
Instead of forget scram, we'll make arrangements for you to do urine testing or whatever.
You hit a cop. You're going in.
However, quote, ordering the defendant to remain alcohol-free and monitoring for her alcohol use with a scram device was critical to the court's decision. Again, stop saying the scram device is critical, because it's just the monitoring part. Given the evidence supporting imposition of the scram device in the first place, as noted above, Judge McCarthy was well within her discretion to conclude that she could not assure the safety of the community if the defendant's sobriety was not reliably monitored. The defendant claims that Judge McCarthy should be aware of alternative testing options is without evidence in the record. Moreover, Judge McCarthy's concern that the defendant manipulated the process is justifiable. Bullshit. Again, it can't be a surprise to the judge, but not a surprise to her. It can't be manipulation on her part that she's in pain when they both knew what her injuries were. That's not new. Defense counsel failed to raise any concerns regarding the defendant's ability to breathe deeply in 2 prior hearings and persistently failed to introduce medical evidence to support her claims. Additionally, there is no explanation for defense counsel's failure to question P.O. January about his email from the night before regarding urine testing or to mention the possibility to the court when given ample opportunity, other than that it was a reasoned tactical decision by a seasoned defense attorney seeking to release the defendant from alcohol testing entirely. Fucking bullshit.
Bullshit.
That is, I'm going to read the footnote first and then we can rant about it.
Let's rant.
And in any event, Judge McCarthy appeared disinclined to consider the urine testing option where it would require release from home confinement. Yeah, we just talked about that and what bullshit that is. Moreover, the testing seems an unreliable means of confirming sobriety when the individual is informed in the morning that they will not be tested that day. It doesn't need to be like that either. It just doesn't need to be like that. Just because that's the way they did it doesn't mean they have to do it that way. You could have to call in 5 times. There would be no disincentive not to drink that day when they are aware that they will not be subject to testing. Hey, I agree with that. I just don't think that that's the only way that they could have done it.
Yeah.
You know what? Just because your probation department is being fucking lazy doesn't mean you can't say, I want probation to call her 4 times a day and tell her whether she needs to go and leave for testing.
I mean, it's
She's
their
supposed to
fucking
be-
job.
Right. She's supposed to be
Literally.
sitting at home doing nothing anyway. So as soon as you call her to go, she should be in a position to just go. She doesn't need to be, you call her 4 times, call her in the morning, afternoon, whatever, how many ever times they want, and say, just like they buzz you on the scram thing, do the breathing. Now someone just has to pick up the phone and tell her, go to a testing. No, you don't have to test right now. Now you do have to test. Or you know what? Require her to go at different times 4 times a day. And she's always going to have to go 4 times a day. And we're going to change the time up every day. And we're going to call her and let her know you got to be there in a half hour. I really need water. And we are almost done, people. We are almost done. Where's our footnote? Okay, we were already through all this. Oh, it was right here. Okay, so we had just read seeking to release. Okay, so let's talk about this for a second. They're saying that he didn't mention the urine testing, which is in the damn email. It's in the damn email, okay? Because it was a reasoned tactical decision by a seasoned defense attorney seeking to release the defendant from alcohol testing entirely. He said, I don't know how many times, Your Honor, we have no issue. We are not trying to get out of alcohol testing or monitoring. We have no issue with testing and monitoring. It's just the method. That's it. That's it. And how is it a reasoned technical decision by a seasoned defense attorney when it's in the email? Well, he's not hiding it. It's in the fucking email. You got nothing, babe? Did I leave everything? What's happening here? Did Bob leave? Oh, Bob left. Sorry, I'm on the other screen reading, so I'm not seeing it. But I don't know. Sounds like complete and total bullshit to me. All right. And then they cite this Pagan case from 2008, and it says a motion to suppress is not a dry run or a dress rehearsal to come back once an adverse ruling is obtained to try and do it all over again. This is not a motion to suppress. That's so very different. That is completely different. That's accurate. You get one bite at the apple on, oh, he brought me a drink. Oh, thanks, babe. Oh, he's so sweet. Sorry, guys. Sorry, guys. Husband and wife combo there. All right. Isn't he the sweetest? He's just the sweetest. So anyway, a motion to suppress is not a bail hearing. I mean, when someone is denied bail, you're supposed to be able to re-review that often. They want people out. You're not supposed to be just holding people pre-trial for no reason. So in sum, the Judge McCarthy acted prudently and deliberately in considering the Commonwealth's request for detention. She considered the evidence presented and made multiple supported oral and written findings, resorting to detention as a last resort. Bullshit. The defendant has not demonstrated that she made an error of law or abused her discretion. Last footnote. 14. Nothing prevents the defendant from requesting relief at a time when the defendant is healed and able to perform the SCRAM test without pain, or if a new testing alternative becomes available. I mean, those are actually not bad points. I mean, is she still in so much pain she can't do it? And, if so, how much longer? And there you have it. There you have it. Let me see what you guys are talking about. We'll get to all your comments. I'm just seeing if there's a question about this.
Hello. How you doing? All right. Are we done with Kelsey?
We are. I was just saying if anybody put a question.
Oh, there was much ranting.
Weird Debbie N. I like Allie's pronunciation of Justin's last name. Hi, Lion.
Hi, Lion. Let me see. Let me get this guy.
All right. There's not a. Oh, here's a question. Can a friend of the court brief be filed on Kelly's behalf? Is that Kelsey's? I'm going to assume that's Kelsey's. Yeah. I don't know Massachusetts law. I had never heard of that before, other than in Indiana in Richard Allen's case. Like in a million years, I would have never thought that any random lawyer could file a pleading into a case that they are not the attorney of record. So I don't know the answer to that. I'd assume no, but who knows? Who knows? Because you can do it in Indiana. Maybe you can do it in Illinois too, and I just didn't know about it. But I've never seen it done in my life, other than on appeals. So you can have amicus briefs to the Supreme Court. I don't know if they do that. I guess that's actually what she's asking here, is because we're at the Supreme Court. I think they probably could. An amicus brief could get filed unless there's a special rule when you're dealing with a single panel. But you can seek to file it, and then it's up to the court to accept it or not. I was talking about just like in her trial case, and that made me think of Richard Allen, where they're just like filing motions at the trial court level when you're not the attorney of record. But yeah, I assume that you can. So I retract everything I said. I assume that you can to the Supreme Judicial Court, unless there's something special with the single panel, because I don't know how the single panel justice thing works, but I'd assume that you could. All right. What's next, baby?
Next, we're going to switch gears and go to the Kyren Lacy case out of Louisiana.
Good old Louisiana.
Yeah, and this is the first time that we're covering the case. And after reviewing some of the evidence and the very recent revelations, this may be one of the more egregious examples of law enforcement misconduct we've seen, which we've seen a lot of it. A lot of it.
Oh.
So,
sorry, hold on a sec.
Here's where I'm at with this.
Scout's calling. Hold on.
Oh,
sorry.
my God. Oh,
hold on.
Wow. She's trying to get her allowance. And, I'm like, you got to do your chores, man. Like, all she did this week is she walked the Nook one time. I'm like, come on, man. Come on, dude. The chore thing is like a constant battle in this house, like trying to get our kids to do chores. It's like, I don't get it. I don't get it. I don't get it. Kids are all spoiled these days. All spoiled. All right. So back to, I'll let Allison, I'm sure she'll undermine me and send her the money.
No, she's not asking me about that at all. She didn't mention money at all. She
She
asked
didn't?
me to bring her sweatpants. I'm like, I just brought you shorts.
All right. Well, I'll undermine myself and I'll send her the money. Oh, yeah. Okay.
So, in any event, this is like, I think Bob talked about the misconduct here, but you're going to understand why, like at the end of this segment, why the Louisiana NAACP is calling for the resignation of Colonel Robert Hodges of the Louisiana State Police, and why Kyren's family and former teammates are saying he was assassinated on social media and in the court of public opinion before any trial ever took place. So let's start with who Kyren. Wait, Kyren's not dead, is he?
Yes. Committed suicide. Yeah. So Allie knows nothing
Oh.
about this case. All right. So let me get into who he was. All right. So Kyren Lacy was 24 years old, and he was from Thibodaux, Louisiana, and he was a wide receiver for the LSU Tigers, where our dear friend Chris went to college. Big LSU fan. I'm going to throw up a pic of him real quick.
I thought you were throwing up a pic of Chris.
Wow.
This is our friend.
This is my friend, Chris.
This is my best friend, and he went to LSU too.
No, I'm not doing that. All right, hold on. Let me just pull this guy up right quick, just so you guys can see who we're talking about. So
I do remember now. You did tell me that he committed suicide because of this assassination, public assassination on social media and public opinion.
So yeah, there's Kyren Lacy.
Let me see.
Aw. Playing for LSU.
How old is he?
Pro day. He was young, babe.
Oh my God, that's awful. How horrible.
Yeah, it's terrible. It's terrible. All right, so that's Kyren. Okay, now we're gonna give you some of the facts of the case. So he played 2 seasons at the University of Louisiana at Lafayette before he transferred to LSU for the last 3 seasons of his collegiate career. And then in 2024, he caught 58 passes for 866 yards, 9 touchdowns. Those 9 touchdowns were tied for the most in the SEC that year. He was projected to be a high NFL draft pick. If anybody is an NFL fan out there, the SEC, that conference, puts a lot of receivers into the NFL. So them thinking he was going to be a high pick is probably right on point. However, on December 19th, 2024, just 2 days after the incident we're about to describe, he declared for the NFL draft, for the 25 NFL draft.
Man, he had like such a bright future. And then you're about to tell us how his life was destroyed.
Yeah. So we're going to go back to December 17th of 2024, around noon. Okay. So Louisiana Highway 20 in Shock Bay. I'm probably fucking butchering that. Lafourche Parish. I'm probably butchering that as well. Is about an hour outside.
All of our New Orleans friends are going to be so mad.
Yeah, they'll let me know. And this is a 2-lane highway, okay, with a posted 40-mile-per-hour speed limit on it.
Okay.
So then Kyren is driving southbound in a green 2023 Dodge Charger, according to all sources, including Lacy's own attorney. He then passes 4 vehicles in a no passing zone at a high rate of speed. This fact is not disputed.
All right. So we got that part's true.
All right. So what happens next is where everything falls apart. According to Louisiana State Police's initial narrative, Lacy's Charger, quote, rapidly approached a northbound pickup truck, end quote. The pickup truck driver took emergency action, and again, that's in quotes, by braking and driving off the roadway to the right. The driver of a Kia cadenza behind the pickup saw the approaching Charger and swerved left to avoid a head-on collision, striking a southbound Kia Sorento. So again, this is coming from Louisiana State Police's initial narrative. Okay. Now,
Right.
in that crash, in that Sorento that ended up crashing, the Kia, was a 78-year-old man named Herman Hall, a Vietnam veteran. He died, sadly, as a result of that crash. Now, the Louisiana State Police concluded that while Lacy's Charger never made contact with any vehicle, his reckless passing caused the chain reaction that led to Hall's death.
I mean, I don't even understand what that means. That it says, he said that he was rapidly approached a northbound pickup truck. So he took emergency action. Like when you were saying that, I'm thinking, why do you need to take emergency action if someone's rapidly approaching you?
Well,
Like-
I mean, just think of it in terms of like when I'm trying to pass somebody on a 2-lane highway and I like make the move, you know what I mean? Like it's usually a truck. So, and I veer off if we're heading northbound and I veer off into the southbound lane and I see a car there or I'm
Oh,
like
he's saying it was
peeking over.
coming towards it.
Yes, they're heading towards one
Oh,
another.
Jesus.
They're heading towards
Okay.
one another.
Sorry.
Okay.
I'm
Do I
thinking,
really need
I was
to
thinking like a
explain that?
4-lane thing, 2 on one side, 2
No,
on the
no,
other.
no. It's 2 single lanes.
Oh,
So-
okay.
Louisiana State Police conclude that while Lacy's Charger never made contact with any vehicle, his reckless passing caused the chain reaction and led to Hall's death. Under Louisiana law, you can be guilty of vehicular homicide, whether the death was, quote, caused proximately or caused directly, meaning you do not have to make physical contact.
All right.
Okay.
So based on that theory, the Louisiana State Police issued an arrest warrant for
Mm.
Kyren.
Indeed, they did. Indeed, they did. So skip ahead to January 8th, 2025. The arrest warrant affidavit states that Lacy was traveling, quote, at an extremely high rate of speed, end quote, in passing vehicles, including an 18-wheeler.
Why
On
aren't they
Jan-
saying on the other side of the road? Because that's what kept confusing me.
Yeah.
Like, go on. So sorry.
Yeah. Well, I mean, it started with the 2-lane highway thing. So I think
Well,
that
because if he's passing the 18-wheeler,
on a
it-
2-lane highway, like
right,
just
but it's
2
not
single lanes.
right, but it's not coming,
Yes.
not
You
coming
have to get into the opposite lane of
right, but that doesn't mean
oncoming-
that you guys are heading head on to each other. If you're
Yes, it does. What are you?
well,
What
if
are you
you're
talking about?
passing him, if you're passing the 18-wheeler, that means you're getting in to oncoming traffic just to pass him.
Correct.
That doesn't mean you guys are head towards.
Yes, we're heading head on. If I see a car heading southbound and I've gotten in that lane to pass like a semi truck, if I
Oh, so
don't
there were
move out of
2
that lane, we're going to
semi-trucks.
have a head on collision. Yes.
Oh, he's passing a semi truck and there's a semi truck heading towards him.
Holy shit. No. So he's in a line of cars.
I
Okay.
lost
One
my
of those
stuff.
4 vehicles.
Wait, I can't even hear you.
What?
And I'm like a stuck turtle on this ball.
Oh, Allie's turtling.
Hold on.
Allie's turtling.
All right, I'm gonna stop asking questions and pretend that I get it.
What's up, T? What's up, T? What happened? Did you fall off the ball when I wasn't
Oh,
watching?
my headphones fell off my head.
Oh
then
my
I was like,
God.
I'm still
Tech
stuck.
wizardry. Wow. No, just turn it. Well, don't break it. No, just gently turn it. No, other
I
way.
think I broke them.
No, you didn't break it. You're about to break them, though. You're about to break them.
Oh.
Oh my
Okay.
God, she did it. She got it. She did it. Wow. Hey, that's why we put the tech
Mandy,
wizardry.
it's gonna have to cut all this out. No one else
Oh,
can see this. Just
Boy. Oh,
just
boy.
you. How many people are here? Just you 613 people.
Wow.
Oh,
All right. So,
Lord. No,
so
I get it.
2-lane
I
highway.
completely get it.
Okay, 4 cars in a row. I'm in the back. I'm like, fuck that. I'm getting past.
An
You're like,
18
but it's a
wheeler.
double yellow, babe. And I'm like, we
Wait,
gotta
wait,
make
wait.
the move.
There's an 18 wheeler in front of us that we are
Yes, there's
behind.
and 3 other cars.
And we are behind them.
We are behind, and we are sick of
Okay.
being behind this slow
So we
ass
get
semi.
over here.
So I go into the other lane that
Uh-huh.
has the traffic coming the opposite way
Right.
in order to pass all these fuckers that are in front
Right.
of us so that we can lead the way and I
Right.
can speed. Like
Yeah, I get
speed.
all that.
All right. So while he's in that lane, somebody coming towards him, oncoming,
So he's
south. They're like, holy shit, there's a guy in this lane.
I get that. So there's two 18 wheelers.
There's not 218
The
fucking
Kia is the one
wheelers.
in the other lane.
It's a Kia's. Oh my God. There's a guy that ends up veering off the road because he's nervous, a nervous Nelly. He's like, holy shit, there's a car and incoming traffic, veers off the road. Another car veers off. And then finally this third car with this elderly gentleman veers off and hits somebody and he dies, or vice versa.
Okay.
You got it?
Yeah.
Come on, dude. That was crazy. It's 2-lane highway, man. All right. So fast forward to he gets the arrest warrant is issued on January 12th of 2025. Okay. So 4 days later, Kyren Lacy is booked in to the La Fourchier.
Right. He's
Am I
booked
butchering
on.
that?
Just say he's booked on charges of.
I'm not afraid of mispronouncing a Louisiana town or parish name because they're fucking La Fourchier, La Fourchier.
I mean, whatever it is, it's French.
La Fourchier, La Fourchier Parish Correctional Complex on charges of negligent homicide, a felony, hit and run driving with serious injury or death, a felony, and reckless operation with an accident occurring.
How can he hit and run if he didn't do the hitting?
Right. I mean, we'll get to it all. You're asking questions that shall be answered.
I mean, if they are all piling up right behind him and he sees it, yeah, you got to stop. You're like, oh shit, I just did that. But
right. So from the state's narrative, it sounds pretty bad so far, right? So
yeah. So did his like NFL draft proposals just evaporate overnight?
Like a fart in the wind. Like a fart in the wind. His invitation to the NFL scouting combine was rescinded, which I know you're not an NFL fan, babe, but like that's a huge deal for
sounds like it.
Incoming freshmen or freshman NFL players, but college athletes that have elected to try to get drafted in the NFL draft, and that's where they all go. They herd them like animals. It's kind of weird, but you have all the athletes out there. They have them doing all kinds of drills and stuff, testing strength, speed, agility, your hands, throwing, all that shit. So all that is ended for him in the blink of an eye. He then doesn't play in the Texas Bowl, which LSU was in his life as he knew it. Everything that he had worked so hard for in his young life and in his college career was over.
Please don't tell me he didn't do these things that they said he did.
So on April 12th of 2025, 2 days before a scheduled grand jury hearing on the case, Kyren Lacy got into an argument with a family member at a home in Houston. During the argument, he discharged a firearm into the ground and then left in his vehicle. So police attempt a traffic stop.
Wow. He's
Lacy
spiraling. Now he's fucking spiraling.
So Lacy flees. A pursuit ensues, spanning several miles before his vehicle crashes.
Oh, Lord.
He is found in the car with a self-inflicted gunshot wound.
Oh,
He's pronounced dead at the scene. His death has been ruled as a homicide or a suicide, rather. He was 24 years old, babe, to answer your early question. He died believing he was responsible for a man's death.
Oh my God, you said believing.
Yeah, believing that he was about to be indicted for negligent homicide, believing that his life was over.
So none of that happened?
Man, have some patience.
I can't. Go ahead.
Matthew Ory later said Kyren, quote, begged me to help him, end quote, and that, quote, this kid had been assassinated on social media. In his mind, he'd already been prosecuted, end quote.
So please do not tell me that this guy might that he didn't do those things and he might have been completely innocent. And that, I mean, how does the cop lie about this shit?
Well, 2025 this month, the truth starts to emerge.
Ay,
You ready for it?
I don't know. Yes.
So on October 3rd, Kyren's attorney, Matthew Ory, appeared on Huma television station HTV in a 44-minute interview that changed everything. Ory presented newly obtained video evidence, body cam footage, and data from the La Forchier, I think I nailed it that time, Parish District Attorney's Office investigation. All right, so here I wanna pull this up. I think I might have it.
If you want me to look for it while you just
No, I think I've got it.
give
I
us some
think
more deets. Okay.
all
I'm
right.
dying now.
So
I'm dying.
I know, it's crazy. Okay, so let me try to pull this up right quick. Because I think we can see some of the video.
Oh my God, this is awful. I
terrible.
don't even know what yet, but it sounds like he
Terrible.
didn't do this shit. And
All right, so let me get over here. Okay. I was kind of looking for the one that he was on, the lawyer.
no, I just at least get us the
Yes,
actual
ma'am.
footage of the
Yeah.
crash.
Okay. All right. So I'll pull this guy up here. Okay. All right. I'll bump
Oh
up
my
the volume.
gosh.
All right. Here we go. Whoosh.
Man, I'm like, this is, hey, we can't hear him, you know. You do know that, right?
What? You can't hear it?
Nah.
Wait, you haven't heard any of it?
No.
What?
No.
What?
And
why
I was
didn't you
still
say
on I was
something?
still on my I was still looking at something.
You just got me sitting here like a fucking moron.
I thought
like
you were
no one
still
can hear
looking
shit.
for it.
All right. Okay, let me try to fix
We're not
that.
going to listen to 44 minutes of the
No,
lawyer.
this is 3 minutes and 17
Okay.
seconds.
I want to see the thing though.
the what we're going.
Okay.
Jeez, your impatience today is at a all-time high. I'm trying. I'm doing the best I can. Let me see here. I'm putting it in a Chrome tab. I don't know what up. All right, let's see.
See, that's what happens when because I haven't been looking at the
All right, y'all. Let me
screen of
know
us
if
this
the sound
whole
works
time.
now.
During
Yes.
that interview shared with us by Homa TV, the attorney says reports between the district attorney's office and state police do not add up. During a recent interview on Homa TV, former LSU football star Kyren Lacy's attorney, Matt Ory, says data and surveillance video shows Lacy was more than 70 yards away from a collision on State Highway 20 in Lafourche Parish that killed 78-year-old Herman Hall in December of 2024.
At the time of impact, he's 72.6 yards behind the vehicles at the time of impact.
Following that
Whoa.
wreck, Lacy was accused of being at fault for the crash and turned himself into state police in January on counts of negligent homicide, felony hit and run.
He hasn't even passed yet. Is that what they're fucking saying right now? So 72 yards, and there's 3 feet per yard. Is that what he's saying? That he hadn't even made the move to pass? Holy shit, dude.
Keep it playing because I'm so confused.
And reckless operation of a vehicle. At the time of his arrest, Louisiana State Police stated that Lacy, who was driving a green Dodge Charger, illegally passed multiple vehicles, causing a vehicle traveling in the opposite direction to avoid Lacy by swerving and crashing head-on into the vehicle that Herman Hall was a passenger in. Ory says Lacy was too far away to have any effect on the crash.
Kyren Lacy did, in fact, pass 4 cars. There's no disputing that. Further north, Kyren Lacy passed 4 cars. However, he was back in his lane of travel, 92.3 yards back in his lane behind Mr. Hall.
Behind.
Statement sent to WWL Friday night, Louisiana State Police said in response to the Homa TV interview, in part, investigative findings revealed that Mr. Lacy's reckless driving while approaching oncoming traffic led to the events of the crash.
The very last line of the report from the district attorney's office says, the evidence submitted in the crash report does not support that Kyren Lacy should have known that his actions were the cause of the crash that happened approximately 72 yards in front of him.
Ori suggests a state trooper was trying to influence one witness on how to describe the crash. But during that exchange, the witness involved in the crash can be heard blaming another driver who is not Lacy before the state trooper redirects the conversation to Lacy's Charger.
What? That lady in the back of me. She didn't know what was happening. That's how she called that record. She was running in the back of me.
So, but the Charger was coming right at you,
Right,
correct?
right.
And that's why you had to slam on your brake, the head on with you. So, yeah, just make sure you include that, and that's very important.
Lacy, one of LSU's top wide receivers set to enter this year's NFL draft, took his own life with a self-inflicted gunshot wound in April.
To this day, formal charges were never accepted by the district attorney. This is over. There's no criminal proceeding.
Done.
This is about making a promise to a kid who begged you to help him.
Oh my God.
And we are waiting for a response after reaching out to the Lafourche Parish District Attorney's Office about the investigation and that Homa TV interview. We also reached out to Matt Ori's office, and we are waiting for a response from him.
Wow.
Oh my gosh. I mean, look, I know nothing like about this kid or his family, but I can just imagine like the pressure he was feeling that he was about to be able to, bring about so much change in his family, by being in the NFL and being able to get money. I know there's a lot of like, you're going to support your family through that. And just thinking he just like let everybody down and that he actually killed somebody like on top of it.
I mean, your life's over. Everything that you worked for, like these kids that just put everything that they have into trying to make the NFL, which is a 1 in a billion shot. I mean, there's 32 teams. There's 53 players on each team. We're a nation of 350 million people. Like super, super long odds, right? So this, like in everything in his mind is gone.
And I mean, it's so commendable that this fucking lawyer even
he
looked
sounds
at
like
this
me.
shit
He's
twice.
fucking pissed.
Right.
All
Like,
so this is one other one I want to play, and this is a prosecutor disputing police claims. Prosecutor disputing the police claims.
Of college football star Kyren Lacy. The Lafourche Parish DA says that the police probe had several inconsistencies and is questioning how it betrayed the LSU wide receiver's actions. Well, earlier this week, state police released this new surveillance video, which they say shows Lacy speeding in the wrong lane and passing 4 cars moments before the wreck. Police concluded that Lacy caused the crash because another car swerved into oncoming traffic. The one-time NFL prospect was days from going before a grand jury in April when police in Texas say he died by suicide. Lacy's lawyer claiming the week that the new video shows he wasn't close enough to cause the wreck. Joining me now, investigative reporter Olivia Rubin, also legal contributor Brian Buckmeyer. So, Olivia, what more are we hearing from the DA's office?
Well, Carrie, you're talking about those inconsistencies that were in the state police's report and their conclusion that ultimately led them to believe that Lacy did cause this crash. But because of those inconsistencies that the DA is talking about, this all really raises questions about whether he really was the one that caused the crash. First, what this DA report is saying is that while Lacy was speeding and was in the wrong lane, he was back in a correct lane well before this crash occurred. That's how the DA's report is framing this. They're also saying that had this been a legal area where you could pass other cars, he would have been back in the correct lane 3 times before, with 3 times the amount of allotted space that would have been needed and that would have been legal had this been a legal area to pass. They're also raising questions about those cars that did swerve and ultimately caused that fatal car crash. Remember, there is a truck, Kira, and there is a car behind the truck. And Originally, police had said that the car behind the truck swerved to avoid Lacy's incoming car. But now this DA's report is saying that that car was way too close to the truck that was in front of it, and that in reality, it could have been swerving to avoid the truck that was in front of it, not to avoid Lacy's car. And then there's also being questions raised, Kira, about the charges here. One of the charges that police were going to pursue was that felony hit and run, raising the fact that Lacy didn't stay on scene, that he didn't call 911 to try to help what had gone on here. But now, Kira, this report saying Lacy might not have known at all that he was involved in this crash. And that's why he left, because he just simply wasn't close enough to know that this was something that he could have had an impact on. And that echoes what his attorney has said publicly, which is that Lacy left because he had no idea that he had caused this crash. Remember, his car wasn't actually involved in the crash there. So a lot of questions raised here, Kira.
So, Brian, explain to us how and why state police and the local DA might draw different conclusions here.
Because one's lying.
Take everything that Olivia eloquently laid out for us, right, and then put it into the framework of this. We're talking about felony negligent homicide. And what that means is you're not accusing Lacy of being the sole contributor to the accident, but a substantial or a substantial one. Let's leave it at that, right? And so we can argue, okay, did he get back into the lane soon enough? Did the other driver see him? Did the gold truck have the opportunity to move? What is substantial? What level of responsibility does Lacy have towards this? And then taking the inconsistencies.
I mean, when you're watching that frame right there and he's back in his proper lane, there is not even an oncoming car in frame at all. You know,
They might not have. They might have dismissed it once they got the video and stuff. Once they saw the video,
what do you mean? They turned it over to defense counsel already.
Yeah, but who knows if they took the time to look at it beforehand?
Oh,
you know
what? He was charged with the shit. What do you mean? If they
based off the cops, what the cops were saying,
huh?
Based off the cops
went out and got all this shit, right? Like that's
but they had manipulated that one witness's statement. I mean, who knows? Who knows if the
I'm not necessarily blaming the prosecutors. I'm definitely blaming the coppers.
Oh yeah, they should have fucking looked at that shit.
Man, this is fucked
You
up.
could see how
my boy
people
Brian
of a reasonable mind would say, okay, Lacy was substantial enough in contributing to this homicide, even though he was not very close. And another reasonable mind saying, no, he was too far away. He was back in the lane, and this person might have turned for another reason. So it's trying to figure out what is substantial and what is not in this argument.
I hate that guy.
So, Brian, Olivia,
you hate Brian?
Yeah, I thought that he tried to give credence to the state's theory.
Wow, I won't tell him you said that. All right, okay, so let's get back to so. I mean, that's where we're at. Okay, so first the surveillance footage from the gas station, which we just saw on Highway 20. This footage, which neither Lacy nor his attorney had seen until recently, shows the entire crash. I didn't see the entire crash there.
I know. That's why I was telling you, get me the crash. You keep looking and I'll talk.
Yeah,
so, I mean, according to the district attorney's own investigation, the district attorney, she's saying that Lacy was back in his proper lane, like car lengths, yards and yards before, almost 100 yards or something before the crash. I don't know. And then we heard what the guy stated on camera. I couldn't hear everything that the guy said when the cop redirected him, but he was clearly starting to tell a story of saying it was her fault, like that someone else had done something that caused the accident. He was like, in my opinion, she's the one that caused the accident. He's like, oh yeah, but that other car was coming towards you. Oh yeah, that was. Okay, let's just focus on that. What in the fuck? I mean, yards behind the vehicle at the time of impact. I'm so fucking confused. Behind the vehicle. That's not how the story was.
I mean, they're showing him slowing and then, I don't know. It's fucking crazy. Yeah, it's crazy. I'm not seeing a video of the actual like accident.
Well, and that going back to like that interview
All right, here, I do like this one, though, because it gives us some more insight, like what was going on. Hold on. This one's got charts and graphs and shit. Demonstrative. You know how we feel about demonstrative evidence. All right, let me see. Which one is it? Hold on.
Cammy Q says Louisiana AG Liz Merrill is opening an independent investigation.
Good. They should. It's fucking bullshit. Somebody needs to pay. Somebody needs to pay. All right, let me pull this guy up. All right, so let's see. All right, so this is like an overhead of the area. Okay, so there's Ori. All right, let's see what.
Tuesday, LSP released nearly 11 minutes of video intended to broaden the perspective. It starts with some of what we already knew and what Ori admitted during the Homa TV interview.
All right, so you see him zooming by. All right, so
Right.
that's clearly when he's passing the vehicles, right?
See, in a green Dodge Charger is seen passing several cars and an 18-wheeler in a 2-lane highway. LSP says it was a no passing zone. He merges back into the correct lane and a crash is heard.
Oh my God. So here he is. You see where he is? The
Yeah.
green Charger there. And you did hear it. Okay, so let's see. You can hear it right there. Okay.
The lane and a crash is heard. Another angle, the angle the public had already seen, shows Lacy a few yards away at the time of the collision. Then what the public hadn't seen.
It's a natural instinct to turn, and then she had no head on.
Is it still green Charger flying that way? A green Charger that's going that way? There's a green Charger. That's a green Charger that caused all this.
Body-worn camera footage records a trooper speaking to several people at the scene of the crash. As soon as he approaches, they seemingly begin to recount what they believe happened. They seem to immediately blame the green Dodge.
There was a green Charger. That's a green Charger that caused all this. SRT8, he caused all of it. He went to pay the cars way back there, sir.
The green Charger collided with these cars.
He went right.
He went around that truck. Okay, he was
passing up
this
with
with
her
her
right now,
and she had no choice.
A person who identifies himself as the driver of the 18-wheeler Lacy had previously passed says the green Charger caused everyone to start hitting their brakes. He and others on the scene explained the car coming in the opposite way and a gold truck hit his brakes and veered off the road. They say the woman in the car behind the gold truck swerved into the other lane.
Wait. This is where he
I want to
says.
go to that chart.
All
I like
right.
that chart.
Passed says the green Charger caused everyone.
Okay, so he's there. He's here, and then he makes the passes, and then he gets here, slows back down. He's behind a white van. There's vehicle number 3. Yeah, this fucking dude in this white car, he swerves into like. All right, so the first guy, this is still kind of confusing because you got this truck here. See this truck? Can you see my little cursor? So I'm assuming this white car is behind this truck, right?
Right.
Oh, and there's another truck behind him. So this guy goes off to the way you should pull off. If you're trying to avoid, you don't drive into you don't swerve into oncoming traffic to avoid an accident. You swerve obviously to the side of the road that you're driving on. So that guy in the truck goes over properly, swerving, even though Kyren's already back in his lane 72 yards away, right? So, and then this white car is the one that plows into this oncoming vehicle. And I'm assuming that's the victim.
Right. So that's where they're saying the white car was too close to the truck because the truck, you're always supposed to have enough distance that, I don't know. Well,
Yeah,
keep playing it because that guy was about to talk about it again.
By the time that white truck or the white, whatever that is, car or truck has visibility, Kyren's like not in that lane. So like, why the fuck is this guy swerving anywhere? There's like, you know what I mean?
Yeah.
There would be no because you wouldn't see that. You wouldn't have seen it if you're behind like a large truck. You wouldn't see shit. that was going on in front of that truck, and you wouldn't see that Kyren had even been in that lane.
Right, you're just following too closely. So when the truck slams on its brakes or slows down quickly and you're not paying attention.
Want to start hitting their brakes. He and others on the scene explained the car coming in the opposite way and a gold truck hit his brakes and veered off the road. They say the woman in the car behind the gold truck swerved into the other lane.
She was coming this way. Okay. They was going this way also. Mr. jumped on brakes. She went to dodge Mr. And that's when she came on.
I was watching. I was by the gas station.
On the left side.
The trooper then speaks to the driver who crashed.
I just know the truck was stopping on brakes. The other car was trying to pass the other car. I was trying to dodge, but not hitting them by coming around.
In the interview Ori did with Homa TV, they show another clip from body-worn camera. That clip shows an LSP trooper seemingly talking to the person who was driving the gold truck.
Just make sure you add in there that you had to slam on your brakes, and the brakes, like, you know, you had to slam on the brakes to avoid that charger, and the brakes locked up to avoid that charger. That's
nice. Big motherfucker. That was even going for. That lady in the back of me, she didn't know what was happening. That's how she called that wreck. She was running in the back of me. She pulled on the other side.
We have not been able to authenticate that video with LSP. LSP told us they can't confirm its authenticity as it was posted to a social media account and not an authentic LSP source.
LSP says they used 21 surveillance cameras and other investigative methods to, quote, uncover the full truth. They say they used forensic analysis, crash reconstruction, and comprehensive evidence.
All right. Thanks so much for that detailed breakdown.
All right. So, all right, we've got some pretty good information there. In terms of what's out there.
Last one that you sent kind of did make it seem more like it could have been his fault. I don't know.
Well, he's already in the lane. Yeah. 72 yards is, somebody do the math. It's 210 feet or more, like 216 feet. There's three. I mean, it's fucking like almost a football field.
Play that there. She says, play that there old Twitter video I sent you from Ryan Clark.
Who?
Mandy. Play that there old Twitter video.
Did she? Where is it?
She sent it to you.
On Twitter or in emails?
I don't know.
She sent it in the fucking text. I'm fucked.
I'm getting hungry. We got to wrap this thing up.
Wow. I haven't eaten. I'm very, very hungry.
I'm sure. Neither of us eaten all day.
Mandy, where'd you send it
to us? Here, I'll email it to you.
Yeah, you play it then. All right. Well, you're getting that ready. I'm going to keep going through like the facts. So
it's ready.
All right.
I'm not you. Someone sends me a text.
Wow. Did y'all hear that?
Pull it up and
hear
play
that shade? Holy shit, that was a lot of shade.
All right.
Fuck, I'm like, I gotta go put on a hoodie because of all that shade. I'm chilly now all of a sudden.
Oh boy.
I thought you said it was ready.
It is. I just had to click share screen.
Sis.
I just had to click share screen.
Keeping time.
Wait, I did it wrong though. I shared the wrong screen.
Wow, 1,000, 2 1,000.
I shared what I share the email.
All that
share
shit
screen. Hold on.
Oh my god, this is glorious. This is amazing. Remember that time when Alex?
There we go. Here we go.
Shit.
You ready? Are you ready?
I'm ready.
You ready for this?
When I thought he died under the weight of handling the guilt that he unknowingly played a part in someone losing their lives. It's even more tragic that I know he died as an innocent man who knew he was innocent, but was dealing with the consequences of someone guilty of what he had been accused of. And let's be clear, Kyren Lacy is innocent, but on December 17th, 2 people lost their lives. Obviously, Herman Hall, and condolences and prayers to his family, because this man fought in 2 Vietnam wars. And the very thing he fought for, right, which was the rights and the privileges and the due diligence of the courts as it pertains to American citizens, didn't even happen in his death. They didn't even honor him that way. It was true lies. It was true railroading. It was true framing. It was Tyler Werner, the state police, who was coaching witnesses into telling them or into saying that it was Kyren's car involved in the crash. All he saw was a young black man, right? He didn't see Kenny, and he didn't see Candace's son. He didn't see a brother. He didn't see a teammate. He didn't see a boyfriend. He didn't see somebody who truly was a part of the community. So they stole his joy, they stole his career, and eventually they took his life. And so now it's about what happens to give his family justice, because this doesn't give them peace. Right? This is exactly the evil and the hate we talk about. It isn't just about rhetoric. It isn't just about words. It isn't just about policy. It isn't just about agenda. This is the true racism and the true hate that takes away lives. And we got to see it right in front of us. And we're having this conversation because Kyren Lacy was a star football player from LSU. How many other young kids, young Black people has this happened to that we will never hear their story? Yep. And I repeat, Kyren Lacy is innocent. Tyler Werner is a criminal. That's a criminal.
The cop.
And so now as we move forward, we have to figure out, how do we keep this from happening again? We have to figure out, how do we continue to keep Kyren Lacy's image and legacy alive by continuing to mention that every time we say his name, Kyren Lacy was innocent. But that won't bring him back. They'll never see their baby
Mandy
again.
had a video
They'll
of
never
the
see their
accident.
brother again. They'll never see their
This is
boyfriend
good.
again. They'll never see their teammate again. And you can't change that. And
preach.
The pain that these people have to deal with over again, knowing that he was targeted, is what makes me the saddest. And so to Kyren's family, to Herman's family, to all the people who lost their lives on December 17th, all of my prayers and condolences. But justice needs to be served, and it needs to be served loudly.
Yeah. Why can't I
Truth.
stop sharing? Where's
Truth.
Oh.
All right.
I mean, that cop redirecting the other car by saying, well, to me, it was, like the woman behind me.
Yeah, I mean, she's the one who clearly caused the accident. I mean, she was driving. I mean, look, I guess you could argue that if Kyren had never gotten into that lane, maybe that truck in front doesn't swerve off the road. But in terms of the reality that this is just some really fucking bad drivers, like some woman tailgating a truck who has no idea that what's going on, the truck overreacting and pulling off the lane, her just following suit because she's
them accusing
following
him
too
of a hit and
closely,
run.
and then she plows into oncoming traffic. I mean, like, that woman is a shitty driver.
Right.
Like that.
And then, but they
that's
also
tragic
accused him of a hit and run when the evidence shows that he very well may have had no idea whether his driving did or didn't. Assuming it did, that he would have had no idea that it had anything to do with that accident, because he had been, in his lane and driving normally for,
Yeah. And so kind of wrapping this up, in terms of the potential criminal conduct by law enforcement, that body cam footage obtained by Ori shows that trooper interviewing the driver of the gold pickup truck, which we watched that video. Remember, this is the truck that allegedly had to swerve to avoid Lacy, which he didn't. In that interview conducted at days after the crash at the driver's home, driver's statement contradicts the state police narrative. According to Ori's analysis, in the driver's own words, the pickup driver did not slam on his brakes to avoid Kyren's vehicle. But here's the smoking gun. The pickup driver was initially cited for following too close. So then, according to Ori, that citation was later altered to crossing left of center, which aligns perfectly with the state police narrative that the truck swerved to avoid Lacy. So, I mean, I'm sure there's going to be more on this, because Matthew Ori is not in any way, shape, or form done with it. Like, he's like everybody that obviously, and you can imagine that the argument that took place at Kyren's house was something to the effect of, you fucked everything up, you ruined everything. with your bullshit. You know what I mean? Like, he's got the weight of these charges out there, and his family doesn't know any better other than what the cops are telling him happened.
Right.
And he's been charged. So now they're laying it on him thick. You know,
Right.
you fucked it all up. You like, we had our whole life was set and you fucked it all up. You know what I mean? You can imagine what was going on in his house when he, you know, dipped with the gun, you know.
Well,
It's
we're going to
tragic.
have to like continue monitoring developments because we haven't seen the full crash yet, which I think is important to see the whole thing. Sounds like there's going to be, you know, more of an investigation, but I'm just going to say no matter what that cop did on that video is fucking bullshit. Like, let the guy that's the kind of shit right there that happens in every fucking police statement across this country. I'm going to say 99% of the times. I have never read. Okay. So even when you take it like the defense gets, you know, summaries, the police reports that summarize the witness statements that are also recorded, right? Or handwritten sometimes, but like recorded. And typically I would tell my staff, you know, you do not go based off of what the cop says somebody said. You've got to read it because a lot of times when we had cases in Spanish, it was like, I'm not saying anything about this case until I get the translation of what this person said on the video, because that's even worse when it's being translated from Spanish to English, that they just take extreme, what's the word? Like, you know,
Is it something that involving your hand in a circular motion? Is it
like
give me
whatever. Like they're just making shit up. Like
Oh.
they're jumping to conclusions. They're not really saying it exactly the way the person said it. Like when someone takes
creative license?
yeah, basically, but there's a
yeah,
word that I can't think of that's there that
wow. Liberties.
liberties. Yes.
Yes, Brian.
Extreme liberties at, you
Brian.
know, summarizing. Thank you, babe. Summarizing what somebody says and then like
It was Brian, not
misinterpreting it.
me.
Oh,
Brian.
Brian. Thank you, Brian.
Yeah.
Thank you, Brian.
Yeah.
Very good. Extreme liberties on that shit. And when it's Spanish to English, it's so much worse because they'll just fucking be you like, that's not what he said because the text and you know, like the man, today's a bad day for my brain. The tense.
I think you're doing great.
Like
babe.
he said that, and embellishments. Yeah. That like the tense is different. He wasn't saying that he did this. It was saying that someone saw that. I don't know, whatever the case may be. But even from English to English, I will not go based off what a cop says, somebody says. 99% of the time when I listen to the video, there is an extreme something either left out, misstated, you know, like shifting, embellishing, and taking liberties, all the things.
All the things.
So what that cop did right there, what that cop did, like literally kind of cutting him off and redirecting him back is bullshit. That's not how you get at the truth. Even if the truth is that this guy's movement somehow, you know, did have an impact, you get everyone's full statement. You don't shut someone down because he's about to say something that doesn't go with what you once said. Asshole.
Somebody wanted you to, I think a little miss really wanted you to say she wanted to hear a fuck face today. So can you give her that? There you go, babe.
Yeah. So
all right.
I
So
don't
you
think we
covered
can do
Kyren.
Are we going to
do it
do
real
now?
quick because I got to put the wheel together real quick.
Real
so while
quick
you're doing
with Kyren and Aiden. All right.
yeah, I mean, because it's
All right, I
pretty
got
much
you.
limited to the issue. Are they or are they not going to be able to access her phones, trying
right.
to find incriminating
Got
shit
it. Got it.
between her and Aiden?
I got it.
Okay.
So you've got the latest battle over the Commonwealth's attempts to search Kyren Reed's phone for evidence of a conspiracy with Aiden to commit witness intimidation. So most of you, I'm sure, have followed it, but just quick background. Obviously, Kyren Reed was charged with second-degree murder in the January 29, 2022 death of her boyfriend, John O'Keefe. And she has since been acquitted of all charges. But throughout all the trials, she's maintained her innocence. And obviously, Aiden was a voice for that innocence. blogger who goes by Turtle Boy became vocal advocate for Reed's claims of innocence. He published hundreds of articles, videos about what he called the Canton cover-up. He confronted witnesses in the case, all the things that Aiden did that everybody knows, but this is not the live to go through it all. So he's facing 16 pending counts related to witness intimidation, 8 felony counts of witness intimidation, 5 misdemeanor counts of picketing witnesses, and 3 misdemeanor counts of conspiracy. And his defense is arguing that it was all protected speech. He was being a journalism, an advocate, and it wasn't criminal. The district attorney, who was also prosecuting Kearney, filed a motion seeking permission to access 2 of Karen
You
Reed's.
did me. You said Kearney. It's Kearney.
Oh, see, yeah, it's like when you're reading it.
No, I see. I told you.
And I'm always like, Bob, we know it's Kearney now. Like, how can you do that?
I'm
And
like,
I
because I'm
just did it.
fucking reading the name Kearney. That's why.
Yeah. August 25th, 2025. So, and these phones were seized back in January 2022 under a warrant linked to Aiden's investigation, but they've never been searched because prosecutors don't have the passcodes, I guess. Anyway, the motion by the Commonwealth wanted to establish the protocols for accessing the phones and to filter out any privileged communications and to compel Reed to provide passwords. I don't see how they're doing that. She does not have to she does not have to provide the passwords for her devices. They can try and get it from, I'll have to see, but I haven't heard of any case where they compelled somebody to do that. I don't know, but the grand jury already declined to indict Karen on the witness intimidation charges, and fine, they want to try again, but you haven't even fucking read the shit yet, and it's already on Aiden's phone. Like, what is going to be different? They all say, you can't delete anything. We're going to get it on an extraction. What the hell could be different on Karen's phone, unless they're looking at like conversations she had with other people that might have been like, oh, me and Aiden are going to do this, this, and that. I mean, I don't know. But the filings show that Karen and Aiden had spoken frequently. She shared some non-public information about her case with him, and the judge allowed them to obtain some of the data in Aiden's phone, messages between him and Karen. So, I think that there was at some point. So Karen Reed's defense team is obviously arguing that there's, a lack of probable cause to support the search. No evidence that Miss Reed was ever urging or suggesting Aiden to do anything. And if the evidence was so crucial, it would already be in the possession of investigators who completed the search on Aiden's phone. They're saying the delay is unreasonable. That's the significant Fourth Amendment violation, is that they're saying this delay, that this seizing of her phone for this long is unreasonable under the Constitution. It's been seized 580 days, and there's no urgency now. Give them back. And another Fourth Amendment concern about the scope and the intrusiveness of the proposed search. And for that reason, the judge was saying, all right, you guys work together to come up with some, like the parameters for the search. So on Wednesday, there was a hearing in the Norfolk Superior Court before Judge Krupp. Aiden appeared by video, and Judge Krupp expressed frustration that the filings from both sides, like at first he said, you guys are all talking past each other, because he thought they already conducted the search and that he didn't realize that they had just seized the phone. So then he figured that out, and he was like, okay, well, if you guys haven't actually searched the phone, now what the defense said might have some merit. But he ordered both sides to work together while he took this under consideration, or he might have also said it for a hearing, or he's deciding maybe if there's a hearing. But he told them to work together to come up, like, over the next 10 days with the search parameters. And he was going to take the rest under advisement, whether they can actually search it. And I don't know what they're going to do, you know.
I feel like they're going to let them look at the shit, man. Like some taint team bullshit. Like
That's a big question. Who's the taint
hard
team?
on. They still
Who's
have a
not
hard on
tainted? Who is not tainted?
on some fucking third party bullshit.
I mean, it would have to be. It can't be like the AG's office.
Yeah, they're all
It can't be
tainted. They are all tainted. Tainted.
So I know. So Tim Bradle had stated
They all
that-
have like this giant hard on still for Kyren, and they obviously have a hard on for Aiden. So, you know, I mean, it's like the real question to me is why the fuck Cosgrove was still in there, why he isn't just, I mean, he has to know. He has to know. He is conflicted out.
Well, technically, it was under Karen's case number. So technically, they weren't.
That's not the point. The
right?
point is
They were under. Yeah, weren't they?
I mean, there's still under Karen's case number for what? Karen's fucking acquitted. She doesn't have any criminal.
I don't know the
cases, bro.
2025. Yeah, I guess not. Right, you're right. I don't know what I'm thinking.
I'm pretty sure we saw an acquittal on that. Karen's
Yeah.
gone in the criminal courts over there. So yeah, no, it had to be, my point being Cosgrove needs to fucking be out. Like,
Right.
why are they? And Bradle asked, he's like, hey,
right.
It seems like we're kind of putting the cart before the horse. Why are we having like Braid or Cosgrove argue this shit? Why is, you know, this moving forward when the real issue should be Cosgrove should fucking be out of here.
And he
Like,
sent
what is
everything.
waiting for?
He said everything on the same day, which one of them's not going to be able to be considered if he decides, yeah, I have to be, you know. Cosgrove said he wasn't even sure who was going to respond. That's why he needed more time. We're not
Yeah.
even sure if we can respond or who can respond or who will respond.
Right.
So he knows that there's issues, you know.
True story.
But so these are you know, the personal cell phones, they've got tons of material that would be outside the scope of this search warrant that's only supposed to be looking for evidence of this supposed conspiracy between Aiden and Kyren. So there's a lot of stuff that they would have to, you know, not view. Also, obviously, any attorney-client privilege stuff. I mean, it's like a fishing expedition for a conspiracy charge. They already have their communication. If it's not there, it's a fishing expedition. It is a fishing expedition. I don't care what they say. You've got no reason.
I don't care.
They've got no evidence, no reason to believe that there's other communications on those phones other than the ones between her and Aiden that they've already seen that are going to provide probable cause that her and Aiden were in a conspiracy. I don't know.
Yeah, I don't know.
You need evidence of an agreement to commit a crime. That they would have been able to have through Aiden's phone already. You
Yeah.
know, but the prosecution, you know, this motion needs to.
It's never ending.
It's never ending.
It's never ending with that case and Aiden. Like, you know, it's with the whole civil thing. Oh, it's like that case just never goes away.
And they're
Never
trying
goes
to get
away.
they're trying to get this evidence to establish this wasn't just like journalism, but a coordinated campaign directed or encouraged by Kyren herself. But again, just like we said, you know, on like the Aaron Spencer case, that it doesn't matter what Aaron Spencer did not know about what a complete and total scum Folsom was. If Kyren was saying things to other people, like, I'm going to give this to Aiden. Like, I'm not saying she was, right? I'm just saying, if there's some text message where Kyren's saying these things to other people, like, I'm going to do this, I'm going to do that, I'm going to get Aiden to do this, that Aiden doesn't know that. Like, that's not relevant. Like, in Aiden's case, that doesn't establish a conspiracy between the two of them, unless it was like, Aiden and I are blah, blah, blah. But they've got to have probable cause to think that there's going to be messages like that.
Yeah. I mean, no question. I don't know. I don't know. I don't know how it's going to play out. It's like, it's just, to me at this point, it's just a fucking witch hunt. You know, it's like they took their medicine and now they're still just trying, they're grasping, just trying to get anybody on something.
It's the whole egg on the face, double, triple egg on the face thing. Why are you going to just keep going and look like an ass again?
All right, so we're going to go through the supers real quick. So that's going to wrap it for our case, True Crime.
Our little
True Crime
felonious
Kingdom.
Friday.
Yeah. All right. So I'm going to go through these quick. I got the wheel set. Kelly K, spin me round, right round.
Right round, baby. Right
And you were on
round.
the wheel, Kelly. Dawn, you guys have become my new guilty pleasure. Oh, like Allie in Bikini Island. Dun, 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 dun,
No
dun,
guilt.
dun, 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 dun,
This
dun,
should be
dun.
your proud pleasure.
Yeah, we don't have to be your guilty pleasure. You throw us on the
Wave
big
your
screen.
flag high. and
Hey, get in
proud.
here, learn something. Thank you, Dawn. You were on the wheel. Not so Zen Jen. Thank God it's Friday. When is retirement? Hopefully soon. Hopefully soon. And I'm talking about for you. Thank you. You were on the wheel. History and homicide. I need a T. Well, you got a shot at winning one. Thanks, History and Homicide. Decline. Love to you both for making my Friday better. Well, thank you. We appreciate that compliment. And you are on the wheel. Stacy, real estate agent. My first ever super chat. Ooh, just want to say we love both you guys. That's amazing. And Stacy, if you're still here, you're on the wheel. And by the way, even if you're not here and you win the wheel, hopefully you'll figure out somehow that you've won the wheel, because I'm going to show you what you have to do. If you do win the wheel, you got to go to our bonfire store. You got to pick which tea you want. You got to say, okay, this is the size and the color.
All right, keep going. You'll tell them again anyway.
Right, those were important instructions.
You're gonna give them again at the end.
Okay. Well, maybe somebody's not staying till the end.
Okay.
Okay,
Somebody put
Stacey,
up
you
our-
were on the wheel.
true
member
crime
for
pod.
15 months. All the love from South Africa. Best law tubers. Oh, thank you.
At
We appreciate you, Una. Mama 2SL Morgan, my mom's maiden name. Happy Friday. Love you all.
If anyone wants to steal his identity, you're getting all of
Hey,
you.
I know, because like Mata's not out there. Emily, $2 holla, a joyful shit show. Love you guys. I mean, what would it be over
If
here
not a
on
shit
DD
show.
if not a shit show?
Especially on
Thanks,
Felonious
Emily.
Friday.
Pam, adorable grandbaby girl.
man.
Thanks for sharing with us. P.S. I took Fenergan.
Fenergan.
I hate that fucking word. I took
All right. For morning sickness.
Fenergan. For morning sickness in the early aughts. Put me on the wheel. You are 2 times for your delicious $10 dono. So the squid, thank you as always, Pam. The squid, cases like this are why I don't trust the state to hold the power of the death penalty. Fucking A.
Right.
And
If there was a magic ball
Roberson.
and I could know beyond anything that this person committed the crime, killed somebody, I'd be fine. I think I'd be fine with the death penalty. I just never get to that sort of moral, philosophical discussion because I can't get past the wrongful conviction side. And
Yeah.
that's where my brain just stops.
The thought of killing an innocent person is fucking horrifying. It's just beyond. For a crime they didn't commit after spending 20 plus years in prison. Una, you were on the wheel. No way either of you two are old enough to have grandchildren. Yet we are. But thank you for that lovely compliment. And you're on the wheel. Meg P, I know you always try to like give your wheel spin to somebody else, but I put you on the wheel. Too bad, Meg. Bob and Allie, we need to go over the latest Scott Peterson docs. They are legit crazy. P.S. Love you guys. We love you back. Thank you.
I'm
And you're
gonna
on the wheel.
look at that as soon as we get off.
Weird
isn't it?
Debbie, I can't pronounce some of the multi-symbolic, symbolic. I can't even say symbolic. Syllabic.
Syllabic.
Thank you, Weird Debbie. Idiot Win coming in hot.
Thank you.
Podcast memberships. You're on the wheel a bunch of times for that. Melissa Powered. Family hug. We love you, Melissa Powered. Welcome to the family. Weird Debbie. Now you're on the wheel. I like Allie's pronunciation of Justin's last name. I think we all did. We enjoyed it. SN, you're on the wheel. Shannon L. Been missing seeing y'all live. Happy I caught this one. Movie quote for Bob. Can I borrow your towel? My car just hit a water buffalo. Oh God. I don't know. I offhand, I don't know it by heart, but I'm going to guess vacation.
I was thinking like a vacation thing too, but I don't know about a water buffalo. So I was going to go with like one of those slapstick,
let me know if I got
country westerns.
Idiot Win. Let's go. Hit that goal. We did, and you're on the wheel even more, Idiot Win, because we love you and you're so generous. Akasha, wheel time, baby. Thank you. Jen and Toxic, I miss you guys a lot. Wheel, baby, you're on there. And thank you, Priscilla Thompson. This is a abomination. I hope the SJC hears it in the recordings. Yeah, me too. And you're obviously talking about Kelsey's case. You're on the wheel, Priscilla. Deborah, Kelsey, you were on the wheel. You delightful gal. Thank you so much for those 5 gifted.
It was Fletch
podcast memberships.
It was Fletch, so it's right up there. I mean, might
I'm
as well
not gonna
be
lie.
Vacation.
Fletch is not in my wheelhouse of favorite
But
comedy.
it's like you said Vacation, and that isn't that.
I know. I get it. I like I've tried with Fletch a bunch of times, and there's certainly places that make me laugh. It's just not a go-to comedy for me. Never has, never will be. I've tried it. I'm like, people tell me Fletch is hilarious. I love Chevy Chase. I should really like this. I like detectives. it's I don't know what it is. Doesn't work for me. Tony, 76, late to the party, but happy to be here. Haven't been able to catch you live for a minute. Go Allie. Go Bob. Love you too. We love you back.
Yes.
Thank you, Tony, for your constant support. Karen. Yes, I'm a Karen.
You're on the wheel.
You're on the wheel. Idiot Win coming in again, smoking hot with 10 DD podcast memberships. 30 total given out by Idiot Win. 30 new members who we love our members. All thanks to the lovely and talented Idiot Wind. Thank you. And you're on the wheel a whole shit ton of times, Idiot Wind. Tony, now you're on the wheel. Happy to be here. I share your outrage on this. What is wrong with these judges? Ugh, I don't know. Wheel time. Sherry S. Gifted 1 DD podcast. Thank you. Family hug. Big hugs for you. Thank you, Sherry.
Thank you.
Or is it Cherie? You think it's Cherie?
Cherie.
Cherie.
I'm going with Cherie.
Kim, member 4 months. You two are wicked
awesome.
Love it. Thank you. Ditto.
Continued support.
Deborah, threw you on the wheel
answered
again.
this, and the answer is yes.
Under the court question.
I think.
Did you answer this one too? I meant Kelsey, and they are legal in MA. The correction, super. Thank you again.
I corrected myself all in that response.
If this had gone to trial, the state would have put on a expert witness with a questionable CV to sync the GPS distance or whatever the fuck.
We see what you're saying. We know where you're going.
We feel you, and you're on the wheel twice because you're amazing. Ophelia Pickles. Family hug. Love that moniker. And then Hope, member for 1 month. Love our Friday evening gets together, or Friday evenings together. So do I. We love hanging with you guys. Love it. Oh, all right. Read that one. I gotta add exhibit.
Exhibit aid is on there like 4 times, I guess. For the trouble Al had trying to put on her headset. That was hilarious. That's getting cut. No one else is seeing
it in,
that.
baby.
Oh my God.
That's awesome.
That was crazy.
It was the cutest thing I ever saw.
Joe Schmo. We know Joe, member for 17 months. Where did the time go? Thanks for your continued support. Exhibit aid. What does exhibit aid get?
A family hug.
There you go.
And a smooch.
Tiff Knox says, I heart you too. Well, we heart you too. And Exhibit Aid gifted 10 memberships.
Oh,
coming in hot.
Super hot.
Debbie King, Scarlett, love y'all and your time. Thank you.
Thanks, Debbie.
Heather B's a new member. What'd she get?
Family hug.
And no, it's me, Randy. You're not too late. So add It's Me, Randy to the wheel. And Debbie King.
And by the way, if you sent a Venmo yesterday, which I got one late when we got off, I have added you to the wheel in all of our Venmos. You're on the wheel. Trust me. We love the Venmos. All right. Okay. So Exhibit A got a whole bunch of tasty little, all right. So Debbie King. All right.
And you got It's Me, Randy.
It's me, Randy. You have to say it right, babe. It's me.
Randy.
It's me, Randy.
We remember Randy.
I remember Randy. It's
me.
me.
What were we calling him? Was that him? We were calling somebody.
Randangelo?
I don't know.
Oh.
I might be getting that could be brain fogging.
The Randalorian?
That could be brain
I got all kinds for Randy. All right. Oh, Oh, under your scars, gifted a late DD podcast membership. Sadly, one gifted DD podcast membership is not wheel worthy. However,
it's appreciated nonetheless.
It's like greatly appreciated.
Yes.
We love you. We love you all. All right, let's pull the wheel up. This thing is chock full of goodies. All right. Dun, 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 dun,
All right, while he's
dun,
pulling
dun,
it up,
dun,
the
dun,
email,
dun,
stop
dun,
making
dun,
music.
Oh,
The
sorry.
email that you send if you win to is a true pod at gmail.com. A true pod as in podcast, but pod at gmail.com.
At gmail.com. There it is. There it is. All right. Okay, you guys ready?
Yes.
All right. This is so exciting. Oh, wait. I gotta shuffle. Because when I type multiple entries in, they all are
Stay right next to
consecutive.
each other. Okay.
So I shuffle it about 50 times.
Okay, it's enough. It's enough.
A little more.
Just click it. I'm gonna starve to
Here
death.
we go. Round and round it goes. Where it stops, nobody knows. Idiot wind! Idiot wind!
Idiot wind!
That is so long overdue. Idiot wind is so so generous all the time. So, all right, real quick, just so you guys know, Idiot Wind, you got to go to our bonfire store. All right, and then which is right here. This should be our store here. Okay, get all this shit. Boop.
I
Move
don't
this
see
shit
it.
out the way. Hold on, I'm still getting there. Jeez. Thanks, impatient much. All right, hold on.
Starving.
Hold on. Yeah, me too. I got the hunger. I got the hunger. I was gonna tell you to dip up and start heating that shit up again, sis. But
I should.
You shoot.
I don't know what 1 minute's gonna
Okay,
do
hold on,
anyway
hold
at
on.
this
All right,
point.
all right, cool. All right, so I'm gonna stop the wheel. Okay, I'm gonna add this guy. Shoopy doopy doo. Okay, all right. So here's our store, our bonfire store. Got that sweet tote, which you don't get. I mean, you don't get the tote. This is it. Actually, if you wanted the tote, and it also comes in this attractive cream, which I don't know how to select. So you can see we've got our old, kind of bullseye scope of a gun DD thing, our traditional logo. We've got my podcast advised me to tell you, come back when you have a warranty. It's everybody's favorite time. It's your favorite time. It's my favorite time. It's your mama time. This shirt never got any love.
Because it's stupid.
It's fucking awesome.
It's your mama time.
No,
Could have
not
said any.
that. It doesn't really say not that one.
Oh.
No, I'm talking about the objection.
Oh.
You suck. Sustained. Like it's just not going normal.
No,
I
but
thought
which
it
is
was so
what
clever.
does it say? It's your favorite time. It's my favorite time. Or is that what it says?
Ellipses. It's like it's always.
Oh, I love
something
that
different.
shirt because
It's
I
a great
love
shirt.
Your
It's a
favorite
great
time.
shirt.
It's my favorite.
If you
time.
listen to the traditional pod, you get it.
Yes,
If you
would.
don't,
I thought it was. I thought you added like it's your mama time, and I was
got
like,
the
well,
sweet keep it simple, smarty. Just a straight up DD shirt right there. God
all right,
dang.
they'll check it out.
Love
I
it.
wanna see it.
Oh, all right. But I digress. As you guys know, I love to say that. Team Allie comes in the glorious purple, which happens to be her favorite color. Straight dope. Just facts, baby. That's what we do. All right. So you guys get the point there. So what you do is you go on there, you select what color, what shirt, what size,
and you email
your address, and like magic, 7 months down the road, you'll get a t-shirt from us. Now it does take a minute because
a couple weeks. It does.
Yeah, it takes a few weeks to, it's because they're as soon as you make the order, they make the shirt allegedly, but it seems to take a while. So, all right, y'all, you guys are amazing. We love you, mods. Thank you 1,000 times over for everything you do. Every single live that we had. Tracy K, we love you so much. Mandy, we love you so much too.
Yes, we do.
You guys are amazing. To my boy Steve, he's not even on here, but publicly buzzed. It's his birthday today. We are rerouting you. We are putting you in the portal. We are redirecting you directly to his live, which I think starts in a little bit, for some Friday fun over there. Check
Always
out
fun.
Steve, and wish him a
Always
happy
fun.
birthday. Yeah, he's
And wish him a happy birthday. Yes, say
Please
Bob
do.
and Allie told us it's your birthday.
Yeah, well, I text him. But,
Okay.
but still send the message. Send the message.
Yeah.
And then, of course, you guys are beautiful, beautiful humans who are with us day in, day out. If you're new, welcome. Please remember to share, like, and subscribe, all the YouTube things. If you're on Replay Crew, leave a little quote. Tell us where you're from. Say, hey, Bob, don't talk so much. Anything, any comment
I don't
in
want
there
to
really
bump
helps
the
us out,
comments like
and it
that.
gets us into the algo. So we love you guys for that, because without you guys, bottom line, I'd just be an old man
Sitting around talking to his wife.
Boo!